அடிப்படை சட்டங்கள் ஆவணங்கள் பற்றி தெரிந்து கொள்ள வின் லா சேம்பர் யூடியூப் சேனலை பாருங்கள். சப்ஸ்கிரைப் செய்யுங்கள்.
Nagarik Suraksha Sanhita. Nagarik is human beings. Citizens are human in the country, then Suraksha is protection. Sanhita is law. Right? Prior to that, if you are having any doubt in your mind that why this fellow is down, he was given a mic there, why is he down means to prevent you from sleeping, if at all. Right? There is no other good intention. Intention is bad. I will just go around and come such that you will be prevented from sleeping. Two disturbances will be there for your sleeping. Yes, ma? No, in sleep also you can be studious. See, for example, if you call me for anything or if I have an argument also tomorrow in a court, I will rehearse it when I was in my bathroom, when I was sleeping, when I was half awake. It keeps inside, it keeps moving. Whatever, even a small thing, and this is a big thing. So you should have thought about my yesterday night. Right? So intention is not good to stand here, it is only to disturb you to the limit, to the extent possible. Okay. This previously, 1860 saw two acts. One is Indian Penal Code, 1861 saw Criminal Procedure Code. And section 4 and 5 should be read like Sri Ramajayam or whatever it is every day of CrPC. What does section 4 says? Section 4 of CrPC says that procedure that has to be followed for IPC offences is CrPC. Right? Then section 5 is a saving clause. And thank God those two provisions, it remains pari materia. It was not disturbed in BNSS also. Any special law will be governed by the provisions under the special law. Section 5 is the savings. Okay. To explain this, I have to ask you one question, personal question to everybody. How many of you are not married here? My God, this is awesome. Only one. How many? Only one. So I can add myself also with you. 2, 3. So I can sum up, in fine I can sum up, only 3 persons are blessed. Right? Okay. Blessed. I can't say that falsity, madam. Right? Second question. Madam's question is for you. The sin of sitting in the first row, that too opposite to the speaker, he will be attacked by so many questions. Okay, but this question should be asked with him. Brother, who was the queen in your family prior to marriage? He is not replying. Video is not recording you, so it will not go to your wife. Video is recording only Chandru.
Neither now nor before marriage. There was no such queen.
So your father kept your mother like a slave? Mothers are queen in every family, generally. You all accept? Okay, what will happen if a new entrant come? Two options. Many times, general law will keep quiet, special law will dominate. Right? The special laws are the daughter-in-laws. And there are some good daughter-in-laws who coexist with rarely. The word rarely. Right? So section 5 says, if at all there is a special law with a special procedure that will prevail, and if that special law does not specifically oost out the general law, then both will co-walk. So this is what we should understand with regard to section 4 and 5, because procedures are very, very important. Even though we say that procedures are the handmaid of justice, procedural laws are very important, and which penal law should be governed by which procedural law is also another one important thing. Okay. This is what with regard to the application of this. What has happened in 1860, the Britishers thought that general civil criminal procedure and penal law should come. Because of this first war of Indian independence, they thought there should be some law. They captioned it as Indian Penal Code, which our parliament now says the intention should not be to punish, the intention is to reform. So the word is not proper, we are removing it and they have put it as it is Bharatiya Nagarik Sanhita. This is the justification of the parliament. To accept it or not to accept it, it depends upon you. But parliament is capable of making law because people have given them the mandate to make laws. They have made it, it is there. Fortunately, many people were thinking that 2024 3 Sanhita will not come after 1st July. Fortunately or unfortunately, it has been implemented, it is the law now. Right. This 1860 and 1861 of CrPC, it was holding good till date. What is the need for a new law? Right. Previously, our grandfathers were walking in pathways. Thereafter, these pathways become cartways. Then it was once again developed as village roads, then state highways, then national highways. Presently, now these national highways got expanded as express avenues, where you should go in 100 km speed. Like that, changes are inevitable in every society. Whether changes are rational, radical, irrational, it all depends upon the ideology with which people perceive that. As judges, there is a law which will be implemented from 1st July 2024. It is for the constitutional courts to check the wires of it, whether it is ultra wires, intra wires, whether anything can be done under Article 13 to strike it down. All these are headache of the bosses. Law book is here, district judiciary, CJMs and magistrates are expected to, and citizens like me, poor people like me, we are expected to follow that. So with that vision we will start the session. So let us not go into the wires of anything, whether it is valid, invalid, whether it is good, not good, it has become a law, right. Take section 1. See, section 1 speaks about short title, extent and commencement, right. You just also see in that book whether extent is mentioned or not. Brother, am I disturbing you by walking? You have to move the video frequently. I have to move. I hope looking all these beautiful faces and lovely eyes, nobody will sleep. You are all looking very smart. Yes. See, section 1. It begins with short title, extent and commencement. You just go through section 1, whether extent is mentioned there. All laws will always say, previous CrPC, old CrPC will say, it extends to whole of India excluding Jammu Kashmir. That was done away with. Now you see whether section 1 speaks about extent. If you want me to speak like an advocate, because you are all judges, good people, you will speak only for justice. We are all advocate. If plaintiff pays me tomorrow, today I will speak for plaintiff, tomorrow for the defendant. So advocates, we are all bad people. If you want me to speak for the central government, I will say, impliedly they have said that Nagaland alone is excluded. So using the implied clause, you should impliedly mean that for other states it is applicable. This is for speaking for the central government. If you want me to speak for the state government, especially your state government, then I will say this is poorly drafted. It ought to, having mentioned in the margin short title extent, they should have mentioned extent. Okay. So the debate, it is food for thought. You keep worrying on that. I will come to second section. What is section 2? Section 2, subsection 1, small a is very, 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 very important. Right? What does it say? It speaks about audio, video. Yes. One thing is, electronic evidence is also considered as a document, and it has received a definition in Indian Evidence Act, that is the Bharatiya Saksha Adhiniyam. However, digital documents are not defined. This is one thing. Please note that what is digital document is not defined in any law. So, where we should see Bharatiya Nyaya Sanhita, Bharatiya, what is this? Bharatiya Nagarik Suraksha says, section 2, subsection 2 says, if anything is not defined in this, you should see Bharatiya Nyaya Sanhita. And if something is not defined in Bharatiya Nyaya Sanhita, you should fall back on IT Act. Okay. So, if anything is not defined in BNSS, you should see BNS. If in BNS it is not defined, you should see IT. But in all this, digital documents are not defined. So, please note that digital document is not defined. Perhaps it will be defined in rules which the state government may also make. So, presently the old definition in Indian Evidence Act that documents are something inscribed on a surface. Right? We will see many documents in public lavatories also, in park trees. Have you seen in any public lavatory you go, in all the walls, in all the doors, because they will take 15 minutes, half an hour of other man's time, no? So they will keep on documenting so many things. In public parks also you see. But in our houses we will not spoil our walls. We are very conscious people, good people. We will spoil only public places, right? Now these documents, earlier we were writing on the floors, on the sand. Then thereafter leaves came. Then thereafter paper, then slates, then boards with marker. So now the dream of the Parliament through section 2 subsection 1 small a read with 530 of CrPC, that is BNSS. Please go to BNSS 530. This is the vision or dream of the Parliament that courts, investigating agency and all organs will become paperless. Right? What BNSS section 530 says? It says everything. To put it short, 530 is the vision of the Parliament that investigation, inquiry, trial, judgments, appeal, all will become electronic in electronic mode, audio, video, and mobile phones are going to play a very, very vital role. Right? Previously itself, no, mobile phone is a big headache. You cannot live without, you can live without wives and not mobile phones. Right? It has become like that now. So 530 is the vision of, if you have to understand the present criminal laws, you should read 530, which says issuance of summons, execution of summons, proof of summons, search, seizure, everything will become paperless. Everything will be in audio, video, electronic mode. Okay, so this time is a transitional period from paper to paperless investigations and courts. This is what section 530 says. Section 2 subsection 1a, you can read one judgment, which is the judgment of the Honorable Supreme Court in State of Maharashtra versus Dr. Praful B. Desai. State of Maharashtra versus Dr. Praful, P-R-A-F-U-L, Praful B for ball, Desai, D-E-S-A-I, 2003 Supreme Court. Okay. What does this judgment said in 2003? This was a judgment in the Supreme Court where a question before the Supreme Court was whether the presence of a witness in physical mode can be replaced by virtual mode. 2003 judgment. A man was in a foreign country. Can he depose as a witness through audio video means? In 2003, definitely Supreme Court would not have prophesied, thought that things will become like this. So please read Dr. Praful B. Desai's judgment, which says presence of a person in physical mode can be substituted by virtual mode. That is the brother judgment for us before this act. Okay, please read that judgment. I will trace so many judgments of the Supreme Court which has in a way contributed for the amendment of CrPC. All these amendments which we find place in BNSS today are the result of so many Supreme Court judgments, and these judgments were recommended by the Law Commission to the Parliament Standing Committee. These judgments were translated as amendments. So one thing is these amendments, but for some amendments, 4 to 5, all other amendments were already put to test and were declared by the Supreme Court. So I think the present law will work, but anything which is new, we will have a what? We will have some hesitation, right? Even for new marriage, How many of you were scared when you got married? Oh, you are all brave people. Nobody is raising the hand. You are all very brave. My brother called me yesterday. He asked me, Suja, he will call me as Suja. Suja, did you reach Karnataka? I said, yes. He has went to Bijapur, so he was not here. He said like this, what are you going to eat? I said, I have to go to canteen. Everything will be very nice, right? Second point, Karnatikas are very good people, very sweet people. They don't fight unnecessarily. Always, my brother gives you a certificate, every time you will say, they are all very sweet, very good, peace-loving. That is the reason I said his blood, bone and marrow has got Karnataka inside, right? Very peace-loving people. Suja, be careful, they are intelligent also. Okay, so he has made me not to sleep also, right? So section 2 subsection 1a is like this. Please read that Praful B. Desai's judgment also, right? Section 2 subsection 2 also we have dealt with. Then for the first time section 2BDE BNSS, section 2BDE bail bond was defined. I will just put it simply to you. You need not break your head much. You can remember nicely. What is bail? A man in a legal custody, either in a police custody or a court's custody, is given custody to a private person. A man who is in a lawful custody was placed with the responsibility with another one fellow that this fellow should cooperate and receive the judgment. This is bail. What is this bond and bail bond? Bond is personal binding of that fellow. Bond is binding. Remember like that, we will not forget and we need not remember that also. Bond is binding. What is that? He executes a bond and binds himself. Bail bond is making another two persons to stand for him. Okay, this is what is said in section 2. You understand, dear judges? Yes. Bond is binding, personal. Bail bond is someone else is giving guarantee. At the time of marriage, the father-in-law and mother-in-law stands as bail bond. Okay, they are the sureties. And if it comes to bond, the bridegroom says, I bind myself to the wife. Okay. Not married, I have the advantage of speaking anything with regard to this topic. You should get scared for your wife or husband. Right? 2 subsection 1 subsection I, electronic communication. This was also introduced. Then 2 subsection 1 subsection L, investigation. Explanation is important. 2 subsection 1 subsection L, investigation. Okay. Who is the youngest magistrate in this group? Youngest magistrate. Question is only simple, my dear. Please raise the hand. Okay, any magistrate can raise your hands. Any magistrate? Amma, the question is, investigation is the domain of whom? I can give only 50 marks to you. See, previously it was section 2 subsection H. Now it is 2 subsection 1 L. Investigation is collection of material by the police or by the magistrate not by the magistrate, but by any person authorized by the magistrate. So please don't imagine always that investigation is the sole regime and realm of police. If something like that is there, then there is no business of 156(3). Suppose the complainant comes and stands in front of you stating that there is no proper investigation, what are you doing? You are asking the police to do proper investigation, fair investigation, speedy investigation, further investigation. 4 investigations are in the domain of district judiciary: proper, fair, speedy, further. Okay, all 4 district magistrate can, district judiciary can order. De novo investigation, re-investigation and investigation through CBI, all these 3 are the domain of constitutional court. I repeat, fair, proper, speedy, then further investigation. All these can be made by district judiciary. Constitutional courts, High Court and Supreme Court can order for a re-investigation, de novo investigation and investigation by the CBI, because you cannot order for a CBI investigation, right? 2H says investigation is collection of material by the police or by the magistrate, but magistrate cannot do. Why magistrate cannot do an investigation? He cannot become a judge of his own cause. He cannot ask somebody to investigate, he cannot investigate himself, and he cannot judge the case. But magistrate can authorize any person, you see the word any person. So legislature believes that if the police is not investigating properly, magistrate has got the power to authorize any person to investigate. So please don't think that police people alone can do investigation. You are the supervisory authority and you are also the body empowered by law to authorize any person. See the word any person, what amount of faith the legislature has got on judges. Okay, this is one thing. Second is, reading of section 2(1)L says investigation is collection of evidence. Is this word right? 2H also it was there. It is they are telling it as investigation is collection of evidence. Is this word right? We will start from the beginning. Is the word collection of evidence is right? There are only 2 things possible. One is Chandru will learn from you, right? And Chandru is not going to give any marks. I am your friend from a neighboring state, that's all. So you can say anything. I can also equally bluff. Okay. Yes, please tell me whether section 2H or 2(1)L which says investigation is collection of evidence, whether this word collection of evidence is right or wrong, say why. Okay. Evidence Act says evidence means, oral evidence means, any disturbance here sir in this? No, slowly please. I don't have anything. My charge or phone? Judges, we should be very careful in addressing. Charge has come down means whose charge? I cannot ask your charge. So I asked whether my charge. Okay, but some charge has risen up. Thank you, Assistant Director. See, section 2, section 3 of Indian Evidence Act spoke about evidence, oral, documentary. Now it is section 2 of the Bharatiya Sakshi Adhiniyam, right? They say, Indian Evidence Act say, evidence, oral evidence means statements made on oath in the court with regard to fact in issue, which the judge either requires or permits. I am repeating for the welfare of the magistrate, dear children magistrates there. Evidence means section earlier 3, now 2 says, evidence means, oral evidence means those statements given on oath which are required or permitted by the court to do so. What is the difference between requiring or permitting? Please read section 3, somebody, some small children in the behind. See section 3 or section 2, read that oral. Am I not visible to this row? It is also good not to see my face for a long time. Yes. Please read section, please give the mic. Do you have a hand mic? You can help some judges by giving the mic. Judge, please read section 3 evidence or section 2 oral. Evidence oral. Somebody can read without wasting the time. Judge, have I got a book? Anything. Please read oral. Document evidence oral. Section 2 also it is there, no. If it is old act, it is section 3. It is new act, it is section 2. Evidence means and includes.
On statements. Evidence
Please
means
listen.
Includes
Yes, Judge.
statements, including statements given electronically, which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, and such statements are called oral evidence.
See, now go to section 2, subsection 1L of BNSS. What it said? Investigation means collection of evidence. What here it is said once again? Our judge has read that oral evidence means statements made in the court which the court either permits or requires with regard to fact in issue. Judge has to answer a issue in consideration, a fact in issue. For that, if the judge permits a man who is in the box not to speak something irrelevant, right? Now two words are there. One is requires or permits. What is the difference between that?
Relevancy.
What is it? Okay. See, you can explain me this concept like you are explaining it to a villager. You are all talking like judges now. See, what is the basic difference between Evidence Act says oral evidence means a man is in the box. He cannot come like that. Either the court should require or court should permit. What is requirement? See, I was given a room in the state judicial, what is that, state academy, what is the state guest house, right? I was given one bed.
Required is summoned by the court.
Required is excellent, judge, beautiful. Permit is
Are you calling somebody as a witness and then take
excellent,
of the court?
excellent. See, permitting means, requirement means I was given one bed yesterday. I want additional things or more things, I ask. Permitting means there is already in all civil cases a list of witness that was given by the plaintiff, list of witness given by the defendant. You permit that fellow to be examined because it is already there. Section 165, section 91, section 311A all will stare at your face. Suppose you want to unravel the truth, you require something more than what is already given, you have permitted something. Now the requirement comes when you want to unravel the truth more. So section 165 is reflected in section 3. Now coming to this is requirement and permitting. Permitting means it is there, it is standing near your gate. You say yes, you come. See, I am standing there, you are telling yes, without permission don't come. Then you say yes, I am permitting, come inside, because list of witnesses by the prosecution, by the accused, by the plaintiff, by the defendants already there, you are telling yes, I am permitting this witness. Or you will ask what is the requirement for this witness. Requirement is, as our judge also has rightly said, you require more. Today morning Satish sir gave me only 2 idlis. What I said? I want one more. This is requirement. Now at this juncture, I want to explain something more on that for the benefit of the magistrates, trainees here. Okay, any trainees judges here? No trainee judges. Yes. One is an evidence, the word evidence is used in CrPC section 2 subsection H of CrPC. Now it is 2(1)L in a looser sense that police people are collecting evidence. It can never be imagined as evidence, or if you want to call it as evidence, it is a prima facie evidence and not a legal evidence. Okay? So that is not a evidence, it is prima facie collection of materials which legislature uses a loose word called as evidence. So what happens? This evidence which is collected by the police as mentioned in CrPC is called as material or police report. This police report can never become evidence. Virendra versus NCT Delhi, VIRENDRA, Virendra versus NCT Delhi, right? Supreme Court, I think it is 97 judgment, Virendra versus State, NCT Delhi. In this, the Honorable Supreme Court says, report collected, materials collected by the police, please listen this very carefully, how beautifully Supreme Court says, materials collected by the police has to be translated into legal evidence in court. Materials collected by the police has to be translated into legal evidence in the court. So, even if you think that what the police have collected it as evidence, it is not. I used one prefix. Legal evidence, excellent. Legal evidence. Supreme Court says materials collected by the police and presented as police report has to be translated into legal evidence. Where? In which place? Box. Why? Then only it will become substantive evidence. A man who speaks or gives evidence in the box is called as substantive. What is substantive? Substantive is real. Right? Evidence given in the box on oath is called as substantive evidence. Point 1. Whether this evidence, substantive evidence, is substantial for answering the fact in issue. See, now we saw prima facie evidence. Supreme Court said it should be translated into box as legal evidence. That is called as substantive evidence. This substantive evidence should be substantial, adequate. What for? Answering the issue, either negativing it or affirming it. This is called as substantial. Okay? If it is substantial, court will not require for more evidence, because parties themselves have already provided. If it is not substantial, court will require for more evidence. Then based on the truth in the evidence, using section 114 of Indian Evidence Act, see, every day I will request all the judges to read section 114 every day. What 114 says? It says, court presumes things on the scale of a reasonable man. That's all. Whether the story projected by this fellow is probable or that fellow is probable. So, who a judge is? That is the reason it is often said a judge is a person who knows no law. Wow, who a judge then is? A judge is a man of rich common sense, and he should work within the framework of law. That's all. Judge is a man who is a wiser man, WISER. He should work with adequate common sense. Right? Some 2-3 months back, had any of you met me in NJA? Any judges here? Some 2-3 months back in NJA, I was taking a session on PMLA, Money Laundering Act. 2 judges raised their hands and was asking questions on community service, because that headache is also there for you, right? One judge, district judge, asked a question, Chandru ji, in Madhya Pradesh High Court has ordered for a community service. Then he told what it is. He said, Judge has ordered a man who is a woodcutter, illegal woodcutter. He goes to the forest, cuts wood. Then the judge said, you come here, you seems to be very poor, I am not going to send you to jail. You plant 20 trees. The accused is hereby sentenced to plant 20 trees and report within a week. Questions by the judges in NJA. Point 1. On whose land he should plant? After planting, who will water it? How long it will be watered? Who will take care? The judge has ordered for community service only one line. See, these are all out of frustrations or anger because the judge thinks this fellow is slaughtering everything. He wants him to plant. Whose land? Whether it is in judge's bungalow or chief minister's bungalow. Because those two are very big. These little people, they live in small huts or they are living in small LIG or MIG. Where is the place to grow 20 trees? So, a judge should be a man rich in common sense and should think that whether this story is probable or what I am telling will be implemented. So, judgments need not be given for the purposes of reporting in papers every day. First thing a judge should think is whether this is implementable, whether my judgment will be respected. You can see every day so many judgments coming out. Can you implement all those things? Many judgments you cannot implement at all. Right? So, this is what section 3 says. So, substantive evidence, probative value of the evidence. Last thing is probative value. What is probative value? Whether it is sitting in common sense or not, whether the version projected by him has a real value or it is sitting in the common sense. See, I have told you already, you as a judge, in a way, you are all very pathetic. Two fellows capable of speaking only lies are standing in the name of prosecutor and defense. What a poor judge will do. That poor judge has not seen the scene of occurrence. He do not know the ABCD of the real truth. You have to somehow believe the stories projected by either the prosecutor or the defense, and you should think whether it is in common sense. Whether it would have happened the way he is projecting or whether it would have happened in the other way. This is what section 3 evidence expects. I want to impress upon you all on section 2 subsection 1L that investigating machinery, the documents that is produced by him is useful only for one purpose. What is that purpose? Police report is useful for only one purpose. Sir? Prior to that, first purpose. What is the first purpose of the police report? Excellent, judge. Excellent. You give a big clap for judge. My brother yesterday said Karnataka people are very good. Clap is not at all good. See, if you clap more, we should always have the heart to appreciate people. You clap more, it is good for your heart. You know that. And can you clap in a court? Even if you feel that the advocate is amazing. So, this is an opportunity for, see, I went to Jharkhand 6-7 months back. They called me for for participating in flag hoisting because the session is in 10:30, right? I went there by 10 o'clock itself. Around 60 judges, all district judges, and they were all very senior judges, it seems. I felt as if I was in a college farewell day because all these 60 judges are just very energetic. They are all singing something, talking something. I felt that it is not a judicial academy at all, Jharkhand. They were very happy, enviously happy. Right? I cannot hold it inside. By 10:25 I went to director's room after all this. I said, Judge, what is this? Your people are behaving like this. They are all just shouting, just singing something, very noisy it is. He asked me why it should not be like that. See, he told this is the only place where my people can come, relax, rejoice, at least openly speak. Right? So, when I ask you to make a clap, no, you may not perhaps get the chance day after tomorrow. Huh? So if you can clap for him. See, what was the question, what was the answer? What do you said, Judge? For cognizance. Police report is material only for enabling the judge to take cognizance of the offence for the purposes of getting satisfied that the way in which it was said, I can issue a summons to a man to come and answer, that's all. Otherwise, any evidence either for prosecution or for conviction or acquittal, you can see only evidence, that's all, okay. So you remember that. From that, where we can go? Okay. Then coming to section 2, subsection 2, we have discussed. What it is? If it is not defined in BNSS, you should go to BNS and IT. Then section 4 and 5 we have already finished. Section 4 and 5. Who you should remember in section 4 and 5? Mother or daughter-in-law? Both. Section 4 and 5. Right? Section 6. Who are all metropolitan magistrates here? Any metropolitan magistrate? Judge, you will not be a metropolitan magistrate day after tomorrow. Right? From first. You are feeling sad or happy? But norms will be very difficult for you, no? In civil court. Who are all assistant session judges? Assistant session judge, there is a post in Tamil Nadu called as assistant session judge. They are above CJM. CJM will give a punishment up to 7 years. Assistant session judges will give a punishment up to 10 years. And two things were effaced, removed. One is metropolitan magistrates will not be there. So you cannot go and say I am a metropolitan magistrate because you think magistrates in villages are inferior. Because of their curse, no. For 70 years. See, these metropolitan magistrates, no, they think they are really big magistrates. So the curse of normal judicial magistrates has worked, sir. Okay. So metropolitan magistrates will not be there, assistant session judges will not be there. So who will be there? Magistrate, chief judicial magistrate, session judges, high court, Supreme Court. So this section 6 you should read with section 22 and 23. You just mark in the book, in the margin, section 6 should be read with section 22 and 23. Then section 15. What section 15 says? Special executive magistrate. This section 15 should be read with section 162. Okay, please jot section 15 to be read with section 162 BNSS. Okay, whether in Karnataka, police commissioners are having powers of executive magistrates? No. Tamil Nadu also it is not there. But from 1st July, the superintendent of police, in the rank of commissioners and superintendent, they will also become special executive magistrates from 1st July 2024. So please note that section 15 and section 162. Then section 18. What is section 18? Public prosecutors. 18 subsection and 18 subsection 1 proviso. 18 subsection 1 proviso. What it says? For Delhi, who is the Chief Minister of Delhi? From 1st July 2024, Arvind Kejriwal will not be appointing public prosecutor. Who will be appointing? National capital, for national capital, central government. Okay, that is their headache and business. I am just telling for information purpose. Okay, it is also in the act. 18 subsection 8. What 18 subsection 8 says? It is equivalent to 24(8) of CrPC. What it is? 24(8) CrPC? 18 subsection 8 proviso. Equivalent to 24(8) proviso. Every victim has a right to engage a pleader of his or her own choice. Why? Our public prosecutors are here. Who are the public prosecutors? Are you worried about this proviso clause? Why? Public prosecutors, some witnesses, please don't feel offended on me, I am telling about the witness. Some witnesses, they think public prosecutors are not they are effective in assisting. Right? You cannot say public prosecutors are not effective. Everywhere. Some witnesses they think public prosecutors, and there are some witnesses who will doubt anything, everything also. Right? See, it is all people, our own family consists of this and that, no? So, public prosecutors, if the witness thinks or the victim thinks that public prosecutor is not prosecuting the case as expected by that person, he can come to the court and file an application. Right? We always tell a old story. Any application filed under 24(8), the judge will say, you come during the stage of arguments. You are all very good judges. You are permitting them during trial. Usually, you file an application for special wakalat whenever there is a government advocate, the public prosecutor. Judges will say, permitted, you can assist the PP at the time of, and you file written arguments. Gone are the days. Right? Please read Rekha Murarka versus State of West Bengal. Rekha Murarka versus State of West Bengal, 2011-2019. Rekha Murarka versus State of West Bengal, 2011-2019, Supreme Court. And in this you can get benefited on 2 or 3 things. What it is, if a victim files an application, along with that you can also, I am sorry for stopping, along with that you can also read another judgment in Aparna Bhatt versus State of MP. Aparna Bhatt versus State of MP, Supreme Court judgment, I think 2019 or 20. Aparna Bhatt, BHATT versus State of MP. Right? Anybody is aware of the fact of Aparna Bhatt? I will talk about Rekha Murarka. First we will finish it. No, Aparna Bhatt is a case where a man like Chandru was wanting to speak to the neighboring opposite house woman. Right? Because that is more interesting to speak with our house woman. This man was wanting to speak with the opposite house lady. He was showing all signals. He wants to give some present to her. This lady offended on that. She gave a police complaint. Our judge, what he did, as a punishment, he said, you should go, stand beside her, give some gift and sweets to her, take photographs. This is what this man is longing for. In fact, this man wants to do that. This lady has given a complaint that my modesty is getting outraged. Our judge said, as a punishment, you go and stand with her. You tie some thread, take photos, give her gift. She is rocked, sir, by this. And the Supreme Court was also rocked by this Rocky. Supreme Court said, these funny judgments should not be written. Supreme Court said, in any case of sexual violence, abuse, the abuser should never see the victim at any point of time, leave alone bail. Even after pronouncement of judgment, it is protected. So, Aparna Bhatt also please read where Supreme Court says any bail application filed by an accused in a case relating with women, the copies of the bail application should be sent to the victim by the prosecutor and by the police also, and defense also should serve point 1. If she should be permitted to file counter, I am talking about victim participation. And even if bail is granted, you should tell that woman that the dog is unchained now. Right? See, you imagine a woman, you just rape a woman or you assault a woman, how many butterflies will fly on her stomach if she sees that fellow once again? I will tell an example. My judge friend invites me to his house. Right? You are inviting me, judge? Definitely. He has a hound or Alsatian dog in his house. Has. So I have also some abilities like Baba Ramdev. But Supreme Court will condemn. He calls me to his house. Right? I go near the gate and ring the bell. What he will say, Chandruji, please come. It will not do anything. It stands up to this place. Right? How many anticipations I will have? how many apprehensions I will have, where it will bite, right? How it will bite, how much of flesh it will take. But what the judge will say, Chandru sir, please come. It will not do anything. It is true only. It will not do anything to him. Right? It will do everything on me. So it has bitten me. It has bitten me. I went to hospital, all injections, everything. Next week also he is calling me. Just imagine an animal biting a human being for only purpose that he is a stranger. Imagine a woman or a child getting raped inappropriately. It is not only the rape of the body, she is put to shame, right? It is just raping of the soul. If that woman sees the man once again, you just imagine the plight. Imagine Chandru's example of a dog versus Chandru. Even going through that lane, no, that street, or even if judge calls me once again, how many butterflies will fly everywhere? So, these are all issues where we should feel sympathetic, empathetic and very sensitive. We should not think that it is someone else's daughter, right? What is the yardstick? If it happens to me, my mother, my sister, my daughter, my sister's daughter, how many butterflies will fly inside? If it is other man's problem, then it is a routine case. If it is our problem, our house people, then it is not a routine case. It becomes an event. Right? So please, judges should have that sort of sensitivity that, see, you people are God. I do not know whether you know that or not. You are all gods in human form. Out of crores of people in Karnataka, God or the system has blessed only few people to deliver justice, man delivering justice for his own men around. Is it not a godly service? It is not a work. You are not paid for the work. It is a great service. One High Court judge, Justice Muthuswamy Iyer of Madras High Court, 130 years, he has addressed judges and said, judges are gods in human form. Judges are gods in human form. Right? And this godly service you cannot do after 60 or 62 or 65. Who knows? I do not know. Right? Either 60 or 62 or 65 or 58. You imagine a day when all the staffs will be around you, nicely take you to the home, okay, with some garland and some ring also. Right? On the next day you just go and touch your robes or want to put that. Is it possible? If you put that robes once again, your wife will take you to hospital. Which hospital? Because every day she will be telling you don't have this thing. See, there is one interesting thing in every home. If the children know, they commit any mistake, father will say, you are like your mother, mindless. Mother will say, that man is like that, you are also like that. Both brainless. So after retirement, if you go and touch your coat, no, she will definitely send you to that place. So you can do all justice only when law empowers you till that age. Right? You will be hailed as God by people if you are just, honest, sincere and also having this sweet face. The moment we go to die, sometimes we become very serious. Right? And one good thing by BNSS is, you will not have any people after some time. You will sit like lone lions in the court, deposition centers are somewhere, advocates will be in his home, witnesses will be from somewhere, deposition center, accused will be in jail. So you can be happy. Court hall, you can see only court halls. After some times also that court hall also will be removed. Because what is the necessity of court hall when great buildings? Okay. So imagine after 5 years, 10 years and 15 years, how justice will be delivered. You will not see any ugly faces or beautiful faces of advocates. You will not be irritated and you will not have the chance of physical, nothing. So whenever advocates are around, witnesses are around, for some time you enjoy with them. Have beautiful faces. Right? In this Reka Murarka, the Honorable Supreme Court has said, if a witness has got a grievance of prosecutor not putting sufficient cross-examination, or important questions in cross examinations are missing, or witnesses are voluntarily not examined. So any grievance of the victim can be addressed. Aparna Bhatt said it starts from the day of filing bail. Rekha Murarka says from even before examination of witnesses. She can say, this witness, these questions are pertinent. Public prosecutor has not asked all these questions. And it also says these witnesses were voluntarily left out. Rekha Murarka has addressed all these issues that judge should put all the questions. If the judge should take questions from the victim and the advocate, and it is the duty of the judge to put all those questions if judge feels the questions are relevant and important. Or else now what will happen? It will become a part of record. If a trial judge does not do that, what the High Court and Supreme Court will do? In spite of the fact that the victim has said all these are important questions, relevant questions, it was not done. So victim theory has gained momentum even from Rekha Murarka. Please read that also. Okay. Section 19G. 19 subsection 3 is very important. Please remember that 19 relates to assistant public prosecutor. One man speaking here, no water is supplied. Sitting and listening, waters are supplied. This is injustice in the society. I am just joking. Right? Gigi, I will not drink water when I am taking classes. I love you, Ji. I love you. I will also give a kiss after the class. Not kiss. Okay. Section 19. Section 19, subsection 3. What is 19 subsection 3 is, there are many courts without an assistant public prosecutor. Now 19 subsection 3 says, the judge can inform the district magistrate of the absence, and within 14 days notice, the district magistrate shall appoint. So please use this provision. 19 subsection 3. You can fill the assistant public prosecutors. You will get meritorious assistant public prosecutors if it is done through district magistrates. Then subsection 20. 20 is also very important. It speaks of Directorate of Public Prosecutors. It also speaks of deputy directors. It also speaks of additional directors. So from 1st July 2024, accountability and transparency will become more, because each director in the Directorate of Prosecution, everybody is given an assignment. That deputy should take care of these cases within 10 years, above 10 years, additional director, deputy directors, assistant director of prosecution. So 20 is also very important. Please see 20 also. Then coming to 22 and 23, this has to be read with section 6. We have already seen, right? What is 22? 22 speaks of only session judge, additional session judge, and what are the judgments that the session judge can pass. What are the orders a session judge can pass? What are the sentence they can pass? What is the sentence a session judge can pass? Death, life. Any sentence, including death and life. Okay, what are the sentences a magistrate can pass? 3 years, and fine amount is increased for first class magistrate. Do you have a second class magistrate? No. Tamil Nadu also no. Right? Now the magistrates can impose fine amount from 10,000 to 50,000. Okay? 23 subsection 2. Magistrates can pass fine amounts from section 10,000 to 50,000. Okay? Subsection 3 is not important for us because there is no second class magistrates. Then coming to explanation. Service, community service. Right? I will please read that. Kindly take note of that. It is a very easy thing. Please don't worry that what is community service is not mentioned. Right? 1. Community service shall mean the work which the court may order. Community service shall mean the work which the court may order a convict to perform. It is the work which the court orders that man to do. I am repeating, community service shall mean the work which the court may order a convict to perform as a form of punishment. For what? For the betterment of that man? No. That benefits the community. So, you should extract some physical work from a fellow. Instead of that fellow going to mother-in-law's house, right? You see the under trial prisoners coming to the court. You cannot see anybody like Chandru, thinny, bony and weak. Everybody will be like my friend judge, looking very smart, very plumpy. Right? Yes. Handsome. Yes. See, now the intention of the new law is to also introduce community service, not for all the offences. Please note down section 202. What are the offences for which you can give community sentence, community service? Section 202, section 209, section 226. Please jot it down. 202, 209, 226, 303 part 2, 303 part 2, 356, 355. I am repeating 202, 209, 226, 303 2, 355 and 356 of BNS, that is IPC. But for this I am repeating, but for this, for no offence you should not impose a community service, because that is not the warrant of law, that is not the mandate of law. Okay, I will tell you some example, another one example also in NJA itself. When this one judge asked about this planting of tree, another judge raised his hand. He said, sir, in our place one judge has ordered for community service. These judges are very advanced in time. Even before community service is coming, they are ordering that, right? One judge, a cow slaughterer, one judge said, you are making this offence of cow slaughtering, that is that man's business, right? This judge now ordered this man to go for a cleansing program of his this thing. Judge has ordered him to go for a gosala for 15 days. Our judges in NJA said, sir, if you permit this fellow to gosala, he will select good cows. What for? Yes. That is the reason I am repeating once again. If at all you give any jovial orders like this, then Chandru will definitely see in paper, will go and say that one of my Karnataka friend judges have given an order like that. I am telling you, I have insisted two things. It is the work which the court asks that man to do for the benefit of the community. I am telling, it is not some psychological treatment. It is not asking him to go to attend Sri Sri Ravi Shankar's ashram. Our intention is not to cleanse that man. Our intention is some physical work for the betterment of the community, which that man knows and has the ability to do. Suppose if you are convicting me under section 202 and asking me to lift so many and all, no, what is that? Stones. I cannot, I will fall and die. So, why it is not defined? People are worried that community service is not defined. It cannot be, because each judge, depending upon that fellow's physique, mental ability, physical ability, topography of the place, geography of the place, so many things plays a factor in that. So you are the sole judge to decide which work he has to do. For example, a mason comes, you are convicting him. You just seek for some government buildings, there will be work will be going on. Send that fellow for 10 days work, and that supervisor should report you. The man who is in charge of that place will come and report, yes, this fellow worked. If he doesn't do the community service, you will recall that, you will give him punishment, he will go to jail once again. Okay? Default in community service sentencing should be, once again you should sentence him. So, two things please underline: work extraction for the, that's all. Please tell your magistrates. Then, section 25. Section 25 of BNSS is pari materia with section 31. What section 31 of CrPC? If at all a judge gives a sentence for, see, it says sentences in cases of conviction for several offences on one trial. Previously what you will do, if you don't mention whether all the sentences should run concurrently or what will happen? Previously, if you don't mention, how it will run? Now the judges or now the legislature says, taking into the gravity of the offence, you should definitely say, or else that fellow should not enjoy concurrency. If the offence is very grave, intention of legislature is it should be consecutive. Okay. Overall view of criminal laws is now the sentences are bit harsh. Why means a community should be a place which should be free of offence, and if at all the crime is proved before the court of law, he should be sent to jail. See, I am telling you one thing. This country is a peaceful country, should be a peaceful country. Nobody should be permitted under any pretext of race, religion, language, right? That is all the domain of politicians to take vote. Judges are gods in human form. You don't belong to any religion, any caste, any creed. Even if your father stands in front of you, you should convict that fellow. If at all prosecution proves the case. And evening you can go to jail and meet that fellow as a son. I am seriously talking from my heart. See, Article 21 says right to life and personal liberty, right? What does it say? No person shall be deprived of his right to life and personal liberty except in accordance with the procedure established by law. Take that no, initial no, and except. Strike both. Now tell me. No person shall be deprived of his right to life and personal liberty except in accordance with the procedure established by law. Remove that no, remove that except. Every person shall be deprived of their right and right to life and personal liberty in accordance with procedure established by law. Why it is starting in a negative is, for a caution it has been framed like that. See, Chandru commits an offence, produced before the magistrate, before the judge now, right? She is taking my liberty by remanding me. This is not an act against Article 21. This is in consonance with Article 21. 354 subsection 3 says, if a man has to be given a life sentence, you can give. If you have to give a death sentence, state reasons. This is 354 subsection 3. 354 subsection 5 says, a person imprisoned for death, you hang him till death. This is also in conformity with section 21. 21 says you deprive right to life and personal liberty in accordance with procedure established by law, because the man was facing a trial and court has come to a conclusion that this is a man who has taken the life of another man. You understand, dear judges? You convict a man not because you are inimical to him. There is nothing called as judge-centric. That is, the judge is a saintly person. The judge sees only the evidence. The judge is not friend or foe of any stupid, right? Judge is a person who doesn't belong to any society. A judge is a good human being with adequate common sense and lot of conscience working in the framework of law. That's all. So, if the judge finds that this fellow has committed a theft, this fellow has caused a grievous injury, this fellow should definitely be sent to jail, whoever it is. If that fellow has not done anything, with all righteousness, we should send that fellow out. There are only two things. So, no judge is an acquittal judge and no judge is a conviction type. See? But your bench clerks, no. They are the certificate givers for you. You know that. Suppose tomorrow I am coming to Bangalore for a murder case. Who is my first guide? You know that. I will come, I will take some Mahatma Gandhi paper and I will show to him first. That is the visa or passport, right? I will come and I will just stoop with him. I will ask him, Chennai kida sir, Uta aita sir, Snana madya sir. Some good words to please that fellow. Then I will say, sir, I am coming for a criminal trial. Tell me, sir, what about the judge? Conviction or acquittal? The judge would have come only 1 week before. Given one acquittal in a hostile case. This fellow will tell, yes, sir, conviction, acquittal type, sir, you conduct the case. Because he knows that whenever I come, I will give some Mahatma Gandhi papers. Right? You should be very careful with these fools around you. He will just subscribe to advocates that this judge is conviction type, this judge is acquittal type. Judge cannot be like that. A judge works on evidence. Okay, dear judges. So, where did we stop? Section 25. If it is a grave or serious offence, please, the punishment should be consecutive. That is what is intention of section 25. Okay. Now the Other provisions are 34G. Please come to 34 subsection 2 Roman 2. Please write 34 subsection 2 Roman 2. This 34, along with 34, please write section 84, 107, 356. 34 subsection 2 Roman 2 should be read with 84, 107 and 356. All speaks about proclaimed offender. Previously, an offence which is punishable for 10 years, you cannot proclaim him as a proclaimed offender. Now 34 subsection 2 Roman 2 explains who is a proclaimed offender. This is the definition. 84 speaks about the process of, you can finish it now itself. 84 speaks about the process of how you declare him as a proclaimed offender. Stages, 84. 107 speaks about attachment of the property of the proclaimed offender. 107. Okay, you can just jot it down, Judge, and also mark. 107 speaks about attachment. Now the law says, 107 says, the honorable judges can also pass ex parte attachment order. On the recommendations of the police, if you feel that that property is not attached, if you give notice, then there is a danger of that fellow alienating the property, you first attach it. There will be no harm in making an attachment telling him not alienate. What will be the harm? No harm, right? So 107 prescribes of all these procedures. 356 is an excellent provision, very laudable provision, because there are lot of cases, in Coimbatore, in Bombay, in many other places, serial bomb blast. What our friend will do? He will have many friends in foreign country, right? He will kill all innocent people here, all innocent people. See, why the only annoyance of me against terrorists. What these terrorists are capable of? They are capable of bombarding trains, bombarding public toilets, bombarding bus stands and innocent school children. Are they courageous enough to fight with our military generals? Rarely they do that. Otherwise, whom they are killing? Innocent people. What a man in a public bus stand will know, right? They just do all the serial killings. Where they are? They will be in some foreign countries like kings they are. And what will not happen? Victim will not even know the judgment of the case, because you can only take evidence in proclaimed offender cases. Previously, you cannot even give the judgment. At least you give a judgment in his absence. The victim will feel, yes, the judge has passed an order of death sentence to them. Now 356 says, like in civil suit, you call the defendant absent and set ex parte. After following the procedures in section 84, you can proceed with an ex parte inquiry, ex parte trial, ex parte judgment. So each stage you should call them absent and set ex parte. You can finally go along with even 313. You can ask with whom you are going to ask. You will say that he has voluntarily absented. Right? In every stage you should call him absent and set ex parte and keep moving. At least properties can be attached now totally. At least the victim will feel that courts are not sleeping. One fellow has killed us, and that fellow, if at all he comes to India, they will put him in this thing. And the period which is prescribed for them to set aside those orders are 3 years. Beyond that, we do not know whether Supreme Court will expand it or not. What courts will always say, if he gives a reasonable reason, that is something else for tomorrow, right? So section 34 subsection 2 Roman 2 has to be read with section 84, 107, 356. Okay, dear judges. Yes. No, this is the proclaimed offender. This is accused when they are outside. See, if a witness is interested, and witness protection scheme is in section 398. Also note down that every state is duty bound to protect the witness now. It is section 398, witness protection. Are we crossing the time? Yes. Please raise your hands. You are all alert, on time. Yes. Yes, section 35. This is very important. Please listen. 35, 1 to 6 is pari materia. Please jot down. 35 subsection 1 to 6 is pari materia of 41 and 41A of CrPC. 35 subsection 1 to 6 is pari materia or equivalent to section 41, 41A of CrPC. Now, 41 speaks about the power of arrest of police. We all know that police people can, or any investigating agency can arrest a person without a, provided the offence is, that's all. Now, second point is very important. This we all know. Arrest is something different from, power of arrest is different from necessity or requirement of arrest. Please write that. You educate your police people. Arrest is not to go and harass and take money. Right? Whenever any Karnataka car comes to Tamil Nadu, my Tamil Nadu traffic police will become very happy. The same is in every state. Right? They will show all their might and right when another state. This is all shame. This is one nation. Right? What a man from Tamil Nadu will think about Karnataka police and what a Karnataka will think about Tamil Nadu police. This is begging. This is not anything. Right? And the only power the police has got is we are fearing that they will arrest. Supreme Court is making a large cry from a long point of time that power to arrest is different from necessity or requirement to arrest. This is where judges should protect the people. The first question by a remanding magistrate to the policeman is, what is the purpose of remanding this fellow? It is not at all mechanical. See. So, Supreme Court, please take the copy of the judgments of Joginder Kumar as a state of UP, 1996, Joginder Kumar was a state of UP, 1996 Supreme Court, Arnesh Kumar versus state of Bihar, 2014, then Satyendra Kumar Antil, Satyendra S-A-T-E-N-D-R, Satyendra Kumar Antil versus CBI, 2021, then I am repeating Joginder Kumar as a state of 1996, Arnesh Kumar as a state of Bihar 2014, then Satyendra Kumar Antil versus CBI 2021, then 2022, 2023, then Muhammad Asfaq Alam as a state of Jharkhand 2023. Please take a printout. Please take a printout. I have to repeat. Muhammad Asfaq Alam versus state of Jharkhand 2023. Okay. For the benefit of the judges who are not aware of this, I am telling, a policeman has got a right of arrest. He has got a power of arrest under erstwhile section 41. 41 capital A was introduced under the caption which is called as 41A notice, that if arrest of the person is not required, you should give the summons to that fellow, ask him to come and facilitate the investigation process. That's all, right? So, mechanical arrest and mechanical remand was condemned by the Honorable Supreme Court in Arnesh Kumar. This is in 2000. It was mainly discussing 498, but it said any offence which is punishable below 7 years, you need not put the fellow in that. But our police, no. Our police, no, because one greatest mistake our constitutional fathers have done is Mahatma Gandhi's photo is in the currency. Police people doesn't want money. They want to see Mahatma Gandhi, that's all. That is the reason they are taking money. One nuisance is, you arrest anybody, you threaten anybody, they will give money. See, this is one thing, what the people will think. This is 75 years more than independence, right? How many cases we are filing? Who is filing cases against police people who are taking money? I went to an academy in Coimbatore. It is one side it is all additional public prosecutor, another side it is DSPs. It was a real grand show. I told them not to record, right? The grievance is AP police people are telling that APPs are taking monies for approval of, they are telling for 302 10,000, right? For each case there is a fixed slab. This is the grievance of these DSP boys are fresh boys. They do not know the nitty-gritties, right? They are feeling irritated because the court PCs, SIs are coming and telling that, sir, 15,000 rupees, 20,000 rupees. So, the allegation of the DSPs is that right from FIR till the filing of charge sheet, we are shelling out 20,000 rupees for one case. Okay. These APPs are telling, sir, these police are collecting money from complainant and accused also. This is the justification that they are giving because police people are taking money from both. See, you go with a case of grievous hurt. You whatever it is, you go with a case of death also, you have to pay. Accused will pay because he is threatened. Complainant will be in he will be in a soup. He will think whether case will be registered or not. So, police is getting from both. And what APPs are doing? To reduce the sin of police, they are taking some money. Like putting in a temple. Right? All these are shameless, honorable judges. My question is, these DSPs are telling APPs are taking money. Whether these DSPs are filing cases as against APPs. And the APPs and DSPs are telling who is more dangerous are the court staffs. That to whom? FIR clerks. Then what is it? Other clerks. Property clerks. Bench clerks. How to come out of all this? How many cases are registered against bench clerks, FIR clerks? If you arrest them, they will reveal more dangerous stories. They will tell them to whom it is going. See, this is all shame to the country. See, what is the lesson we are teaching to our children? Right? How many police people are in jail? How many cases are filed against corrupt people? How many cases are filed against court people, police people? We all talk, I can only talk. You are the gods, I told that you are the gods. We will see from 1st July how many affairs, so much affairs you are going to register. I went to Madhya Pradesh. I met one person, Samir, very lovely man. Right? There was one case, if you all can read that. Jayant was a state of MP. Jayant was a state of MP. 2020. Right? I do not know that I will meet that magistrate in my life once. I met him 6 months back. His name is Samir. He is now the CJM in Madhya Pradesh. This lovely man, what he did is, I admire that fellow. Right? I just gave a nice hug to that fellow. In Jayant was a state of Madhya Pradesh, what has happened is, in Madhya Pradesh, there is a practice of revenue authorities to arrest the mines and minerals accused every evening. Beautiful story. These are all shame on democracy. Revenue people will arrest the sand miners every evening. They will take them to revenue authority place. Then they will impose fine. They will make a compounding. Then after 1 hour or 2 hours, they will let them out. Why? For tomorrow morning's work. What is tomorrow morning work? Same work. Revenue Tahsildars will arrest them, take the tipper, take the lorry and all, because for statistics they should maintain all this. Tomorrow morning they will be led by the Tahsildars to go there, and evenings they will come. This one magistrate, a man with a spine, he saw this in some newspaper. He took so moto notice of this under 156(3). You read that judgment. This magistrate, he became the complainant. He is the applicant to his own self. On that paper, this man took suo moto and issued notice to 20 to 25 station house officers and told them, directed them to register FIRs on the revenue officers and all the lorry people. Right? This man told me, I met him, he said, Chandru sir, you know how many threats I have received from my superiors, from police superiors, but in spite of all that, it went up to Supreme Court. Supreme Court said, this man has did the right thing. Motos. Judge, if somebody doesn't build the cat, okay, this society cannot be reformed. Parliamentarians can make laws. If police people and revenue people are too corrupt, then it is for the judges to build the cat. Jayant was a state of MP is there. I have also given the citation where Supreme Court has approved that our friend Samir's endeavors. Unimaginable, no? Magistrate taking note of something, taking suo moto, asking to register FIRs on all the jurisdictional SHOs. You see how that, what will be the result, and who is the reason for that man's all this, no? Who would have supported this man? Who is the better half? His wife is his batchmate judge. She is an MP MLA judge now. She is a MP MLA judge of the Madhya Pradesh. Both husband and wife, they are telling that they both spoke with me. I am talking in front of video. They said, Chandru sir, what people will do at the maximum, what they will do? They will kill. That's all. Let that happen. Now that lady told me I am in MP MLA's court. What people will do? Everybody knows we are fighting for justice and law has given us that power. So still there are people, still there are good people, too good people. That is the reason it is raining always. Okay. Then please take all those judgments. Along with that also read Siddharth was a state of UP 2021. Siddharth judgment. See, usually some charge sheets are filed under section 170, you know that, 170 CrPC. A case where investigation is not very elongated, usually the traffic cases, no, small cases, prohibition and traffic 170. Cases of those nature, police need not arrest and bail is not mandatory. This is what is said in Siddharth was a state of UP 2021. Okay. Then 35 subsection 7 is a new law. 35 subsection 7. What it says? 35 subsection 7. I will read from second line. It is easy for understanding. What 35 subsection 7 says? In case of an offence which is punishable for imprisonment of less than 3 years, see, it should be an offence which is punishable for less than 3 years, and such person is infirm irrespective of age or is above 60 years of age. Come to the first line. No arrest shall be made without prior permission of an officer not below the rank of DSP. This is one new inclusion. So, remanding magistrates should be very careful. If a man who comes with an FIR, if an accused who comes with an FIR for remanding, the offence is punishable less than 3 years and he is an infirm man like me or he is an aged man and also 60 years of old. Okay. So, this you should be very careful. 35 subsection 7, please note it. Then 36 and 37 read together. 36 and 37 read together. Now, a designated officer will be appointed by every state and it is the duty of the designated office of all the police stations to inform about all the arrest. Previously, when a policeman arrests a person, God only knows where that man is, because they will not keep in the very same police station, right? Even guards will not be knowing, policemen will be knowing that better, right? It is not the duty of guards to search for all this. So, whenever a policeman arrests a person, now 36 and 37 says, there shall be a designated officer who should be arrested about all the details, right? Who should be detailed about, and that designated officer should display in his office with regard to who is arrested, in which station he is, where it is kept, all the details for all offences, right? This is section 36. 7. 40. Now private arrest is also there. Any man who does a private arrest, now what he should do? Within 6 hours of arrest, he shall hand over to the police. 6 hours. Previously no time limit was mentioned, now the time limit is 6 hours. Then previously the word used is, if the man after arrest hand over to the police, police should re-arrest. Now police will take custody because arrest was already made by way of a private person and 6 hours time is provided. See, this is all expandable. If that man comes and says why he cannot hand it over within 6 hours, if he says some reasons, it is reasonable, should record that and write, that's all. Or using this, the man in custody will file a case as against the man who executed the private arrest, that beyond 6 hours it becomes he will go to National Human Rights Commission, that's all. It will facilitate advocates to earn there also. Then 43 subsection 3. From 1st July 2024, we will see accused with handcuffs in the corridors of the court itself. Right? Previously, magistrates were given the power to decide whether the accused should be in handcuff or not. Right? I don't think this is too fair a law. Right? This is talking from the side of a humanitarian lawyer. All policemen will be happy on this. Because for them, if they handcuff a person, they will be scot-free. They need not have the pain of just monitoring them. Policemen will be very happy. Now, set of offences were given for which handcuffs should be put. Now you write some 2 or 3 judgments. What is the famous judgment? Sunil Batra. Sunil Batra versus Delhi administration, 1979 and 78. Sunil Batra versus Delhi administration, 1978, 1979. 2 judgments of the Supreme Court. Then Prem Shankar Shukla versus Delhi administration, 1980 Supreme Court. Then Prem Shankar Shukla versus Delhi administration, 1980. Sunil Batra versus Delhi administration, 1978 and 79. Then Citizens for Democracy versus State of Assam, 1995. Citizens for Democracy versus State of Assam, 1995. These 4 judgments run contrary to our present section 43 subsection 3. These 4 sections, I want to repeat. Sunil Batra versus Delhi administration, 78, 79. Then Prem Shankar Shukla versus Delhi administration, 1980. Then Citizens for Democracy versus State of Assam, 1995. These 4 judgments said police should not. These 4 judgments said if at all police should put a man in a handcuff, magisterial permission is essential. Magistrate should apply the mind and see 2 things. One is whether this man is a danger unto himself. Because there are some accused, what they will do, they will hit their own self. They will put the head down, they will dash against something, right? So, if a man has to be handcuffed, police will show that he is a dangerous person for himself or dangerous to others. Second is, he has got a propensity to escape from custody. These 3 were the yardsticks for putting a man in fetters, iron fetters. Now, unfortunately, legislature says, taking into consideration the nature and gravity of offence. See, nature and gravity of offence doesn't have anything to do a man with handcuff. For example, it says if a man has raped, if a man has committed a murder. See, murders, private murders are there. Suppose my neighbor is irritating every day. After killing that fellow, this fellow will become remorseful. Why I did that? This fellow will feel remorseful, he will feel very weak. Like that, no rape cases. After that, it is all harmonical imbalance. After that hormonal imbalance, this fellow will remorse. Why is that I did? He will, and putting that man in fetters, no, and making him to put more shame every day, right? So putting a man in iron fetters, the yardstick of nature and gravity of offence is not a true yardstick. However, now common man will understand that if a man is an iron fetter, a man will understand, a common man will understand that this fellow has committed a serious offence. That shame should not be, because the second question, if it ends in an acquittal after 5 years or 10 years, can we compensate that man the shame which he has underwent? And all the offences which the police registers, complainant gives, cannot also be presumed as true. So I think that some constitutional, perhaps Karnataka court also may struck it down.
In subsection 3,
Anji.
they have defined the offences, they have given the list of offences where handcuffs can be.
That is what I am telling. Gee, that is what I am telling. Now they have given a list. They are telling that taking into consideration nature and gravity, they have given a list. So either the police or the court do not have any say in that. You should see the FIR. If it has to be arrested, then you should do that. My question is, you cannot presume that all the informations are true, right? And it will end only in conviction. If you put a man in fetter for 10 years in court, after 11th year you say prosecution has not proved the case, what is the shame he undergoes out of that? So perhaps 43 subsection 3 may be struck off because of the judgments of the Honorable Supreme Court already, right? Now whether this 43.3 is legal or not, morning I have said this is a law of the land. And presumption is, legislature is aware of all the Supreme Court judgments. In spite of that, by march of law, it has designed this. Okay? Yes. 43. Okay. Then 48. Obligation of person making arrest to inform about arrest, etc. to relative or friend. In this also designated officer is there. Besides informing the relatives and friend, designated officers has also to be informed. Now section 50, only a small addition is made. Second line, immediately after the arrest is made. Seizure of weapons, offensive weapons has to be made immediately. This is the inclusion in section 50. Then 51, 52, 53. We will finish these three provisions and we will wind up for lunch. Before coming into section 51, 52, 53, you write some 3 or 4 judgments which are very important. Kishan Kumar Malik, Krishan, K-R-I-S-H-N, Krishan Kumar Malik, M-A-L-I-K versus State of Haryana, 2011. Krishan Kumar Malik versus State of Haryana, 2011. Rajendra Prahalad Vasnik, Rajendra Prahalad Vasnik versus State of Maharashtra, 2018. Rajendra Prahalad Vasnik versus State of Maharashtra, 2018. Then Chodkau versus State of UP, Chodkau, C-H-O-T-K-A-U, Chodkau versus State of UP, 2022. Munna Pandey versus State of Bihar, 2023. Munna Pandey versus State of Bihar, 2023. And another judgment is Ravi versus State of Maharashtra, 2019. Ravi versus State of Maharashtra, 2019. Beside Ravi, you write it, DNA results are scientific in nature and reliable to an extent of 100%. Besides Ravi judgment, you write DNA, results of DNA are scientific in nature and reliable to an extent of 100%. Supreme Court in Ravi versus State of Maharashtra, please read that judgment. Supreme Court has explained the credibility of DNA examinations and the results thereof. It doesn't mean that only with DNA result alone you can convict a man, but reliability Because it is a 100% scientific evidence, it is reliable to an extent of 100%. Okay, I will tell you a small story. I know that it is all, you are all hungry. Right, one girl, 8 years old. You know Kothkai rape case? Kothkai rape case. Kothkai, 2017, Himachal Pradesh. I will give that district judge's judgment to our Satish ji. Please read that Kothkai, Kothkai, Kothkai rape case. 2017, in a forest in Himachal Pradesh, Shimla, forest name is Hailela. In Hailela forest, this school girl, 8th standard studying girl, after the school, she was returning to the home. And if at all you are adapted to the villages, no, and forest areas, children will not walk on the main roads. They know some little this thing. No, she is a small child. She will not know that a human being like that will follow. Right? I will not call that man as an animal. Please don't term any man like that as an animal, because paper says animalistic act by a man. No animal will do that. Right? No animal will take a towel and follow the female animal and put it in the mouth. Right? And no gang rapes are also there in animal kingdom. And no animal will put its hand or feet inside the sexual place. Right? We are capable of doing all divinely act and all demonly act. So you please don't term any rapist as an animal. You don't degrade animals. Right? This is a case where the child was followed, smothered, and the trick of these people, no, the committing rape, they smother the child or woman first. Why? Excellent judge. Please give a clap for her. Excellent. Who worries whether she cries or not? To avoid resistance. They are so lazy that they don't want to fight and rape. I am telling you one thing. Take idiotic husband or wife in the house. Idiotic. Who will be troublesome wife, you know? Troublesome husband. Lazy people. Every crime, every problems you can connect with laziness. You cannot find in matrimonial cases also a man busy like you fighting with his wife for divorce. Rarely only a non-lazy man will come to court. Any man who is tightly packed with work, norms like you. Suppose if High Court doesn't takes the norms off, no, you will also start more fighting with the wife. Thank God norms are there. See, every lazy man will do some crime. And this lazy fool, he smothered it, he just turned the head of the child, raped the child and left off. Right? It became a big news. Shimla is a tourism place. It became a great news in all the TVs. Immediately what the DGP did, he went for a camp office there. What will happen? Our police knows both astrology and astronomy. You know that. Their investigation is only out of their gut feeling. They know Chandru will do this. Raman will do this. Things are not scientific. They immediately, because DGP came, they should tell the public, no, we have arrested. Beautifully they have arrested some 6 innocent persons. Innocent persons. They would have been tall, black and ugly. Man very, like wheatish, white color, having all this will not do anything. This is our expectation. Right? They arrested 6, thrashed all the 6, 1 died. Custodial violence. Immediately what has happened? The rape and murder become a small issue. Killing of a tribal person become a big thing. Then DGP ran out of that place, said CBI will follow. CBI came, collected the swab from the girl, and that swab was dissected. Swab is the secretion in the vaginal portion. Collected that, dissected that, and made an analysis called as YSTR analysis. That is, Y denotes the male chromosomes. Because if I commit a rape on a woman, my chromosome sperms are also there and her secretions are also there. So a dissection was made under the caption called as YSTR analysis, and they had the DNA material matched with all the 6, 0. Right? Materials collected from the child doesn't match even to an extent of 0.001 with all the 6 including the man who died. Then the original FIR was scrapped. CBI put another one FIR. Now they are having a DNA material with their hands. They went on around the village and took the samples of many people. Out of 400 sample, one man was caught, but that chromosome was not matching 100% with the 6 they were released, sir. See, they are already having YSTR analysis, male chromosome, they are having male sperm they are having, they have taken a DNA material with them, and out of 400 people they have examined, one man has got 25% matching with this. That means one family member of this man has committed. Okay. Then what they did, they called this fellow, they investigated him and put a family tree. Now CBI and forensics should make a lineal DNA search, right? Then they called everybody, searched, none matched. Then out of the blue, one man said, we have got one relative, he will rarely come to this place, he is a woodcutter, previously also he has done some offense. Where he is? No, he is not connected by anything, sometimes he will call us. And after 1 or 2 months, this fellow called one relative, CBI just traced that, nabbed that fellow, matched it 100%. Now imagine, had this one man not died, what will happen? Police will project this 6 in all the photos, right? 27 Evidence Act is there. We will believe that one panties of the girl and panties of the boy, 1 or 2 this thing, they will say that we statement disclosed, it led to discovery of all this. These 6 fellows would have died by then, because it is a media trial, we will put all of them in this thing. So now BNSS is insisting for any offense which is punishable, 176(3) of BNSS says, for any offense which is punishable more than 7 years, DNA is mandatory. Okay, we will resume the class after post lunch. I love you all. Bluffing is very easy. Attending for that very patiently is very difficult. So I love you all. Thank you so much. When 176 subsection 3.
I request Shri E.V.Chandru sir to continue the session.
Good afternoon, judges. Oh, which is the provision we left? 55? 51, 52, 53. Okay. Yes. Okay, we'll start. Yes. Are you all happy after eating? Yes. What was very special in today's food? Is sambar special, madam? No, dosa idli. Jalebi. Okay. You had vegetarian or non-vegetarian? Oh, no non-vegetarian food. Okay. Before lunch, we were discussing about section 51, 52, 53 of BNSS. Okay. In BNSS, one of the main features of the present DNS is forensic evidence, DNA analysis, using mobile phone for audio video electronic means. Apart from that, every stakeholder will have a time frame, including judges, right? These are the main features of the present BNSS. 51, 52, 53 has to be read with section 184 of BNSS. 184 relates to section 164 of CrPC. That is, examination, 184 speaks about examination of a rape victim. 51 speaks about examination of an accused on request of police. 51. Medical examination of accused on the request of police officer. This is 51. 52 speaks about 52 speaks about examination of a rape accused in specific. 52 speaks about examination of a rape accused. 53 speaks about medical examination of the accused. 51 is on request of police. 52 rape accused examination. 53 speaks of medical examination. It also 53 speaks of one more examination. That is, if the court wants or any other authority wants, that fellow has to be examined once again. One more examination was also provided. Okay. These are all stated in 51, 52, 53, read with 184, which is in relation with examination of rape victim. Now, my question to the learned judges is, in a case of sexual violence, a penetrative assault or an insertion, right? Examination of the victim is more important or the accused is important? Which is more important? Victim. This will be the common answer. Both is the right answer because there are two types of, in a rape, if it is done by the male organ, it is called as what sex? Penetration. If it is done by penis, it is called as penetration. Insertion is by any other object. Okay? Because it is starting in PEP, you understand that in this thing, right? Invariably, in all the medical papers where the woman was penetrated by a man in a rape, this thing, you will see doctors writing as 12 o'clock injury. That is a tear in the upper portion of the vaginal portion, right? 12:30 injury, 6 o'clock injury, 3 o'clock injury. All this denotes the tear in the vaginal portion. Now, medical science believes, and the Supreme Court also says, if a man could penetrate and tear this much, what should be seen in the accused? Reciprocal injury. In that score, examination of this fellow is very, 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 very imminent and important. To fix two things, from the morning I am telling two things, that an innocent should never be punished, and a real culprit or a guilty should definitely be sent inside, because such a person doesn't have any place in the civilized society. Okay. It is the expectation that reciprocal injuries should be taken note of immediately, because if you arrest that fellow and send him to medical examination after 3-4 days, what will happen? What will happen? Injuries will get, that too for small boys within 25-30, injuries will get cured within 2 or 3 days. And apart from that, it will be healed. Apart from that, the DNA materials or the secretions from this poor girl, saliva, bite mark, nail markings. See, nail markings depends upon the fragility of the girl. Suppose you smother a girl, she cannot put nail marks like a tiger. Right? Even if it is a small child, no. That child may try to bite, that child may try to do something. You cannot catch one ant like that. Even an ant will resist. So, in any sexual violence, that is the reason morning I said, these lazy fools will first, what they will do, they will smother and put them in an aspecial state because they are not worried about human beings. The conduct of them is not love at all. It is something erratic. See the case of that small girl who died in Delhi. Nirbhaya. You just read the judgment, right? And see that small child, 20 years old child, the injuries are from navel till anus. A open injury from navel till anus. What is the extent of injury? Almost the entire stomach is torn because these 5 to 6 fellows, they want to do a penetrative assault. Science says if you are drunk, no, penetration is not very effective or possible because alcohol in the body will make the blood vessels dilate. Right? It will not make the blood vessels contract. Penetration is a process where pumping of blood should be too much for penetration. But they have went with an intention to penetrate. When they fail in doing that, they could not do that. They saw for some other object. They had hand with them, and they also had a large pipe, which is used to tight that this thing. So this is the human mind. They want to do something. They cannot do with their organ. They did something. They took the uterus of the child out. Right? In this course from the morning I am telling parentage is very important. Responsible children will come out, responsible people will come out only by responsible parentage and good neighborhood. Right? Now 51, 52, 53, it speaks of examination of the accused because this accused will also have so many matters and materials in connection with the offence which he has committed as against the other person. In a fight also, if two persons fights, he gives an injury, they also give an injury. It will explain and establish the presence of the man in that place, point 1. 2 is, this reciprocal injury, this man is now answerable. He should say, under section 106 of Evidence Act, this fellow should explain how he has sustained an injury at this point of time when a girl has said it is because of this act. And all other materials like hair, pubic hair, secretions of the girl, saliva of the girl, so many DNA materials he would have carried in his body. So protecting that in order, see this is for the welfare of the criminal justice system, I am telling. I am not talking that everybody should be put to jail. If this fellow is the real culprit, he will carry so many materials, examination of him immediately will render real justice. So please advise the people down the line and also the stakeholders that the common knowledge or the common belief that the victim should be immediately examined, equally important is this fellow also because he also proves the case. Okay, this is one thing. Coming to, we saw 4 judgments in the morning. I dictated 4 judgments. One is Krishan Kumar Malik versus State of Haryana. Another is Rajendra Prahlad Vasnik. Third is Chotka versus UP. 4th is Munna Pandey's case. Hey, this Krishan Kumar Malik case, anybody has got a phone with you and a net also? Just type the judgment, Krishan Kumar Malik in Google. Krishan Kumar Malik was a State of Haryana. It will not work here. Okay, I will tell. In Krishan Kumar Malik, why I wanted you to see that is, Supreme Court has said, it is the mandate of CrPC, section 53 small a, CrPC 53 small a, and now it is 50, 51, 52, 53, that medical examination means, small a, examination means examination of sperm, swab, sputum, saliva, hair, then nail clippings and any other DNA examination. This was introduced in 2005. Krishan Kumar Malik, Supreme Court said, why is that prosecution and investigating agency are failing to take DNA evidence and send it for forensic examination? Now it has become a mandate of law as per section 176 subsection 3 of BNSS that any offence that will be punishable more than 7 years, it shall do that. And policeman cannot escape saying that no DNA facilities, forensic is not available. It goes to the extent of saying in the proviso that state government should publish, notify that if I do not have such a facility, I am referring this to the other state. So please, as judges remanding, no, remand judges should definitely, it is the duty of us to see to that culprits need not escape and innocent accused also doesn't suffer, and victim should be protected, right? Please think about the plight of a victim who believes that, see, there are two persons who are key persons in a court of law, in a criminal justice system. One is an accused, another is a victim. An accused is a man who says to you that his right to life and personal liberty has to be protected. No doubt it has to be protected. Victim is a person who has already lost his right to life and personal liberty. Either the victim died, so legal heirs will be anticipating some good will be done by these gods, right? Next is a man who would have lost his limb, eye, suffered something. He is a person who believes in the system much. How? He just goes and gives a complaint, rest assured in his house, thinking that state is taking care of me and judges are taking care of me. This investigating agency should be sensitive enough, prosecutor should be duty enough, and judges should also be godly to see that justice is done. Okay, this is a man, victim is a person who sits in his house believing that the country is taking care of me. Such belief has to be protected. Okay, in Krishan Kumar Malik, Supreme Court referring to, sir, you have got it, sir. Please go to find and put sperm, SPRM. Go to find. In that, go to find and put sperm. Okay, you just search it. My question is, in a rape victim, right, after a sexual assault, a man ejects sperm in her. These spermatozoa, how long it will be active in the vaginal portion? 72 hours is one answer. Then 14 hours. 48 hours. Then see, have you taken sperm? Anybody has got it? Huh? Amma, read that para, Amma. Please give mic, pa. That para, start. Yes. Please kindly attentively listen.
Spermatozoa may retain vitality or for free motion in the body of a woman for a long period, and movement should always be looked for in wet specimens. The actual time that spermatozoa may remain alive after ejaculation cannot be precisely defined, but it is usually a matter of hours. Seymour claimed to have seen movement in a...
1 second. Seymour means he is like our Modi's jurisprudence. Okay? He is a foreign authority on that law. Seymour.
In a fluid as much as 5 days old.
Once again, read from Seymour.
Seymour claimed to have seen movement in a fluid as much as 5 days old.
5 days. Seymour says he has noted down movement of the fluid live spermatozoa for 5 days.
The detection of dead spermatozoa in stains may be made at long periods after emission when the fluid has been allowed to dry. Sharp
is another authority.
Identifiable spermatozoa often after 12 months.
12 months.
And once after a period of 5 years.
5 years.
Non-motile spermatozoa were found in the vagina after lapse of time, which must have been 3 and could have been 4 months.
4 months. Non-motile spermatozoa, thank you, Judge. Non-motile spermatozoa without movement, it is inside the vaginal portion of a woman for 4 months. Krishan Kumar, Supreme Court, taking from the medical jurisprudence of foreign, why I am telling foreign countries, it said, common belief of every person like me, it is 14 hours, 40 hours, 20 hours. Investigating officer will also believe like this. And what he will say if a girl goes after a week? Have you taken bath? Finished. Have you urinated? Sir, when we can believe that it is 20 hours, 24 hours, think of a policeman who has guided him that it will be like this. So for heaven's sake, please tell them down the line, there is a judgment where foreign authorities says that it all remains for a very long time. This will aid in a woman to get justice. Why I am telling is, a woman will get justice. Right? After all this is for justice. Right? Please have Krishan Kumar Malik in your this thing. take a printout and give it to your doctors and give it to the investigating agency also. And the PP brothers and sisters have got a greater responsibility. Please tell them that it is like this. Let them not say that the child has taken a bath, everything is finished. Non-motile spermatozoa in the vaginal portion remains for 4 months. Right? So let them first believe that there is something like that. For that only I am just telling you this. So equally important is Rajendra Prahalad Vasnik, Chodka's case, then following Chodka is Munna Pandey. In all this, Supreme Court has condemned the investigating agencies or the prosecuting authorities for non-examination by way of forensic evidence, or even if the forensic evidence is available, either the prosecutor would not have marked it or the court has not relied on that. So all these judgments says in unison that DNA examination by way of forensic evidence is very essential and integral for any criminal justice system. Right? Morning I have told you about Ravi versus State of Maharashtra 2019. In that, what is the proposition? DNA tests are reliable for an extent of 100. Now you should not mistake that if scientific evidence is given to me, then I should give a judgment positively. Okay, for that I will tell you another one example. In Madan Gopal Kakkad versus Naval Kumar Dubey, 1992 Supreme Court, Madan Gopal Kakkad versus Naval Kumar Dubey. Madan Gopal Kakkad versus Naval Kumar Dubey, 1992 Supreme Court. This is a case, listen this also very carefully. So what is section 45 of the Indian Evidence Act? Second word is very important. Experts? Yes. You ask judge whether Chandru is a good person or not. What will be his opinion? I do not know. You ask her, she will say, he is my brother, he is a good person. You ask her, no, he is my villain. Opinion differs from person to person. Point 1. Opinion always remains as opinion. Opinions are not judgments. Who is capable of giving a judgment? The judge, who by law is vested the power of giving a judgment. So section 45 has to be always reminded that any opinion comes, it is subject to further scrutiny. Second man will say the reverse of it. Okay. See, opinions are like this. Your mother will always say, my son is. Wives will say. Okay. I was told that it is relayed also. I was also told not to speak much. Right? Truth should not be said much. And second, I am telling this story of this Madan Gopal Kakkad case. A school going girl, an MBBS fellow is an accused in this case. He was doing his 5th year, what is called house surgeon, internship or house surgeon. This is a fellow who is capable of penetrating young girls without inserting, without hymen tearing. Okay. This is that fellow's crooked mind. He has committed that. Child reports to her friend. After some time, then it was reported to the mother. Both all went to the police station. Child was taken to the doctor. Doctor gives a report that hymen intact, no rape. Now doctor has become judge. Excellent judge. Beautiful answer. Doctor has become judge. Doctor can say Chandru has got a piles because it is a medical condition. Doctor can say Chandru has got jaundice. Doctor can say Chandru is suffering from fever. Doctor can say he has got a teeth which is caries. Doctor can never say there is a rape. There was a rape. He can say child told that she was raped. Point 1. That is reading the history, examination. Doctor can say on naked eye examination, I saw injuries. I saw redness. I saw bruises. I saw cut. He cannot say that no injuries, there is some reddish contusions around, hymen intact, so no rape. Because of one foolish doctor, I am consciously using the word foolish doctor, the child's parent went up to Supreme Court for 18 years they were loitering. One man in the system, no, in a responsible position, is like an atom bomb. One man in a responsible position can spoil the entire system also, if he is dominantly, right, if he is not knowledgeable. This man wrote like that. What our judge did, he was carried away by the medical opinion. That judge, perhaps if he thought that this is only an opinion and has read section 375 once or twice, what 375 says, slightest penetration also, that judge should have read 375, 376 once again. He should have read the caption of section 45, it says only expert opinion. Then the sessions judge acquitted. High Court said it is neither rape nor not rape. High Court said it is 354 outraging modesty. Even after the child's evidence in the box that fellow penetrated, High Court was of the opinion that it is only 354 capital A. Supreme Court said in one word beautifully, rape is not a medical condition, rape is a crime. Condemning the doctor, you see the language of the Supreme Court. Rape is not a medical condition. Why? Doctor cannot say so. Rape is a crime. This was the beautiful judgment laid by the Honorable Supreme Court to direct judges to teach us how to attend a medical expert opinion's view. You can always differ from a medical, from any expert's view, right? All this you should read. This is up to section 53. We will read conjointly 184 also. What is 184? Examination of a rape victim. Now it is said, you cannot examine a woman without her consent. This is one thing in section 184. Then, doctors are not agencies for character certification. What these doctors does? What they do? A woman or a child goes with a story of rape or a penetration. The child goes bleeding with a torn, with a tear. What our doctors does? What test they are doing? One shabby test. Not one finger, it is not sufficient. Then he gives a character certificate. She is adapted for sexual these things, right? In Lillu alias Rajesh versus State of Haryana, Honorable Supreme, Lillu alias Rajesh versus State of Haryana, Lillu alias Rajesh versus State of Haryana, the Honorable Supreme Court has condemned this practice and said this character certificate is not essential, right? He should examine the child, he should see what is the injury, that's all. Now 2023, State of Jharkhand versus State of Shailendra Kumar Rai. State of Jharkhand versus Shailendra Kumar Rai. 2023 judgment. It says, any doctor who practices two-finger test on a victim should be actioned against, action has to be taken for medical misconduct by Medical Council of India. Okay. So 184 also specifies that examination of women should be conducted within 24 hours. Please also note down that on the consent, and it should be made within 24 hours because it is all DNA materials. She may lose it, right? This is 150, 152, 53, read with 184. Then after that, '54, identification of person arrested. Okay, proviso 54 proviso, just audio, video, electronic means were added. So identification parades can be recorded henceforth by audio, video, electronic means. Especially if you have a mobile phone also, you can do that. This is 54. 58. Last lines, whether having jurisdiction or not. Person arrested not to be detained more than 24 hours. Only last line is added, whether having jurisdiction or not. Okay. Then 63 to 71 speaks of summons to witnesses in electronic form. 63 to 71 speaks of summons and warrant Okay, it is summons. 53 to 71 is only summons. Summons in electronic form. We have read in the morning itself section 530. What 530 says? All inquiry, trial, issuance of summons. No? Yes. Now, without reading 63 to 70, please take 71. What 71 says? Notwithstanding anything in the preceding section. That is, you need not worry about 63 to 70. 71 says, notwithstanding anything contained in the preceding sections of this chapter, court issuing a summons to a witness may, in addition to and simultaneously with the issue of such summons, direct a copy of the summons to be served by electronic communication or by registered post addressed to the witness at the place where he ordinarily resides and to the place of business, work for gain. Previously, working for gain and place of business was not there. It is like CPC, right? What I want to say to you is 63 to 70, it is insisting you to send the electronic process. 71 says simultaneously you can do both because legislatures knows that infrastructure is not yet developed. So you need not worry that from 1st July 2024 we should immediately switch over to electronic form. So kindly note section 71 also, it says you can do it in either of the forms. Okay. So you can issue summons, you can serve summons, you can record proofs, everything you can do digitally. If digital things is not available, you can also do it by paper form also. This is in section 71, 63 to 71. Then coming to 82, subsection 2 is a new addition. Subsection 2 should be read with 36 and 37. 82 subsection 2 should be read with 36 and 37. What is 36, 37? Designated police officer. Morning we saw, no. There will be one officer called a designated police officer. So 36, 37 and 82. What 82 subsection 2 says? Arrested persons, all the information relating to arrested persons should be given to designated officer. Okay. This is 82 subsection 2. 84 we have seen in the morning. I told you 4 provisions to be read together. 34, 84, 107, 356. Am I right? 34, 84, 107. Yes. Now 34, proclamation of person absconding. What are the process you should take care for the purposes of proclaiming him as an absconder? 34, it is the definition. 107 is attachment of the property. 356 is ex parte inquiry, ex parte trial and ex parte judgment. Okay, judges. Then, with regard to handling warrants, warrant and cancellation of warrant. No. Previously it was 70 subsection 2. My question is whether in Karnataka you maintain a register called as NBW Magister? No? Raghuvansh Devanchand Basin. Raghuvansh Devanchand Basin versus State of Maharashtra. It is a 2011 judgment. Raghuvansh Devanchand Basin, BHASIN versus State of Maharashtra, 2011. The Honorable Supreme Court has given various directions to all the high courts and the subordinate courts as to a separate register for non-bailable warrant should be there, because every warrant issued by the court of law should have a specific time. If not executed, it should be received back from the police or misuse will be there by the police. So please read Raghuvansh. If you are all principal district judges, any PDJs are there, please maintain a register. Supreme Court had said long back and many states in the country are maintaining. Okay. Okay, next is 86. Identification, attachment of property of proclaimed person. Question is, can the police attach properties? Can police people attach property? No arrest, madam. See, I go in a vehicle, motorcycle, Suddenly one policeman stops me, takes the key and attaches my vehicle. That is what property? Small property. Which law gives him movable property attachment rights? What is the difference between seizure and attachment? Is there any difference between seizure and confiscation? Sir, seizure, confiscation. What is the difference? Morning I told you one example in Jayant was the state of Maharashtra. What I said? Every morning you can go for stealing sand. Evening you should go back, pay fine and take your properties. You read Mines and Mineral Act, it says properties used like that has to be confiscated. Chandru takes a knife and put into the stomach of a man. That knife will not be given back to Chandru. That knife will be seized. Right? One man snatches a chain from me. That is given back to Chandru. You seize something, return it to somebody because that is not basically a material of crime or a proceed of crime. That will not be used for repeating the offence. Any confiscation proceedings in Forest Act, Mines and Minerals Act gives the power for that authority to confiscate, that is to make it as a state's property. Suppose if all these tahsildars or revenue authorities are conscious enough of the provisions for confiscation, they confiscate the tipper and lorry today. Right? Tomorrow if the man wants to do that, what he should do? He will purchase a new thing. So the intention of legislature on any confiscation is it should be made as a state's property. It should not be given back facilitating that fellow to commit the crime. Now, attachment of immovable properties is not the domain of police. Attachment of immovable property can be made by any investigating agency on permission from court. Niveda Properties Private Limited was a state of Maharashtra. Niveda Properties Private Limited was a state of Maharashtra. Honorable Supreme Court says in 2019, Niveda Properties Private Limited versus state of Maharashtra. 2019 Supreme Court. Supreme Court says that police persons should not be given the power of attachment of immovable property. Reason is, in a democratic country, if police is given the power of attaching, Supreme Court says it will become anarchical. What is anarchy? Lawlessness. Supreme Court has stated in what judgment? Niveda Property Private Limited that attachment of any property should be done only in consultation with the or from the concurrence from the court. So please read Niveda Property along with 86. What 86 now says, if at all any property has to be attached, the superintendent of police should seek the power. That power is not given to all station house officers. So please read that, section 86 also. Right, section 94 and 95, there are no much changes. Deletion of 94 and 95, there is only a deletion of the word telegram. Telegraph authority, those words were omitted. Okay, 94 and 95, the word telegraph was omitted, that's all. Then 105, recording of search and seizure through audio, video, electronic means. Previously I told you another one section, that proceeding should be recorded by audio, video means. What it is? Superma, test identification period. Okay. Now the question is, previously this is now it says search and seizure of the police has to be recorded by the process of conducting search of a police or taking possession of any property, article or thing under this section, including preparation of the list of all things seized in the course of such examination, shall be recorded through any audio, video means. It is not may. So section 105 says all search and seizures has to be recorded by. Now my question is, previously police can happily sit and write in the table, they can search anything, seize anything, only form 95 will come. Now two difficulties will come to police. What are the two difficulties? One is they should first prepare. First preparation, see, before shooting preparation will be there, no? No, you don't understand. You judges are very good people, you are not thinking crooked. From the beginning I am telling, see, I am not criticizing anybody. From the beginning I am telling, you should be very strict with criminals. You need not stage manage anything. See, if you fabricate an evidence, you are also a thief, no? Your intelligence is to such an extent that you should nab the person and collect the evidence. It is not planting something, purchasing something, planting something, stage managing. All these are fraudulent activities. It is all fabricating evidence. It is punishable. Right? Now that will be the difficulty. Point 1. Search and seizure will be in. Yes, judges will have so many jobs now to see. From the morning till night you will see only what? Videos. Take care of your eyes also, audio videos. You will be bored. Then section 107, attachment, forfeiture and restoration. I have told you in the morning itself, you can also give what orders? Ex parte, excellent judge, ex parte. We discussed this 107 when we read 34, 84, 107 and 356. Okay. Please read that very, very carefully. Now section 109, power to impound document, etc. produced. Any court may, if it thinks fit, impound any document. Any court may impound any document or thing produced before it under this Sanhita. Okay? Whether this is correct, can the court impound a passport? Then what is 109, Judge? No, 109. Any court, impounding means to cancel a document is also impounding. Impounding is not only the process of passing orders to make good the loss of stamps. That alone is not impounding. Impounding is to cancel a document. Okay? 109 says you can impound any document. But sir says,
But the interpretation is recently in Karnataka High Court judgment, the interpretation is made in relation to Passports Act. There is one judgment, very recent judgment of Honorable Justice Suraj Govinda.
okay,
Vis-a-vis CrPC and Passports Act as interpretation.
by reading 109, what example you are remembering? 109 is a CrPC. You are talking about, don't you remember mother-in-law and daughter-in-law? 109 says court can impound any document. Suresh Nanda versus CBI, Supreme Court, 2008 judgment. Suresh Nanda versus CBI, 2008. Supreme Court says courts are powerless to impound passports because, as sir has rightly said, what act is there? Passport Act is there, section 10 is there. Section 10 of Passport Act says only the central government or the passport authority has got the power to impound. Suresh Nanda versus CBI, 2008 Supreme Court. Supreme Court has said courts do not have any power to impound a passport because impounding of passport is provided under section 10. Okay. When there is a special law, generalia specialibus non-derogant. Generalia specialibus non-derogant. That is, when general laws will not affect special laws. Section 129 BNSS. There are some small corrections, there are some small amendments in C, E, G. 129 BNSS, some corrections are in C, E and F. That is, the names of the old laws were removed and new laws were inserted. Like example, In E, it speaks about protection of civil rights. Previously it was Untouchability Act. Now it is Food Safety and Standard Act in G. Previously it was Prevention of Adulteration Act. Okay. So it was some amendments. Then orders to be made, 130, section 130, orders to be made. In that last lines, what does it say? Number of sureties and after considering the sufficiency and fitness of sureties. Previously, it was character and class of sureties. Those words were removed. It was character. I told you my example. Who can assess anybody's character? Nobody's character can be assessed. Morning if you get up, you are getting like a saint. Right? When days goes on, you become like a villain. And night also you feel that I cannot do anything in this society, then you are hopeless. So character, it keeps on changing. Right? Previously the word character was there, it was deleted. So you need not ascertain the character of the surety. Whether the surety is sufficient or not, that's all. So the words were appropriately used in the present law. It is in 130. 145G equivalent to section 126 of CrPC. 145 equivalent to 126. Previously, a poor father and mother who obtains an order of maintenance, if they want to enforce it, they should go to the place of residence of the son. You know that? Now, the old parents, after getting order, they can trouble their children where from? From their parental place. Those children have to be troubled. Because? Why? They have neglected. That is the right answer. Those children are worth troubling. See, children should feel a responsibility and they should feel happy and proud that it is my father-in-law who has given me body and this thing, money. Right? Honorable judges, I will tell you one thing. Any person, let it be a aged parent, let it be a wife, any person who comes to you with a petition for maintenance, either under 125 or under the relevant provisions of DVC, Domestic Violence Act, it is section 20, right, or under section 24 of the Hindu Marriage Act, a woman, a child, a parent who comes to you with a petition, imagine that it is equivalent to begging on the streets, right? With no hope of life they are approaching you. You see how shameful it is to ask money with a person. Can we afford to go out and ask for 1 rupee on the street? These people, because they think that you are the only source, they come and tap the door. And even if maintenance petitions are kept for years together, just imagine a situation where I said I have got a good parents. Imagine a scenario where my mother was begging in the court when I am studying first or second standard, right? And also imagine a judge sleeping over a maintenance petition for 5 to 6 years or 10 years. What would have happened to my mother's life and the education of the child? Can you have a Chandru or can you have so many judges here? If our parents had been to a maintenance court and maintenance was not given by the judge, in fact, if maintenance is not given, 2 or 3 generations will get spoiled. Just imagine, if they don't have anything to eat, how the woman will send the child for school. So please take maintenance issues as very, very serious. Right? What are the 2 things to be seen? Whether marriage is disputed or not, whether that man has adequate resource to pay. Adequate means he need not be like Ambani. He will be having something. He is potent enough to have a daring decision to marry. He has also married, procreated children. Now who will take care of that? So maintenance petitions are very, very serious. Too serious. I am using the word that the woman or the father begs with you for money. They are literally begging without a plate in their hand. They are begging. So all dilatory tactics of the other side has to be curbed only by the honorable judges. If I appear for the husband also, what I will do? I will advise him, we will prolong the matter. Once the husband senses that this cannot be prolonged in this court, he will definitely give. It is all the signal which the judge should give. If a judge says all these dramas is not permissible here, he will definitely give. In so many cases, he will throw out one wife and small children, he would have married a second woman. What is the counter they will file? No, presently I am married, having children through her, I have to take care of my second wife and children and also my parents. See, by giving not maintenance, I am repeating, second, third generation will get spoiled. So, this is a welcome move. Section 145 says, old parents need not go where that fellow is. They can get maintenance from their place itself, right? This is a good move. Section 148. Okay, I have to ask one sensitive question. Which gender is very powerful? Very delicate question. But I want all of you to raise the hands. Which gender is very powerful, male or woman? How many of you say woman? Please raise. So you are all surrendering to woman. Accepting the fact. Oh my God, please give a good clap for sir. Accepting the fact. See, any civilized society, if it doesn't respect a woman, I am repeating, any civilized society without respect to women, that society will never progress. Right? Women should be respected and worshipped because they have a special ability over and above the man to procreate a child, have it there for 12 months, which is very difficult. Very difficult, 10 months very difficult. You go for a feast, eat nicely 1 or 2 plates of biryani. I am talking about my male friends. Okay, you eat a full meal and drink also ice water 1 glass and see whether you can walk, you can sleep, you can lay down on the face. Very, very difficult. They all had us in their stomach for 10 months. They have given all, I told in the morning, all of you are looking beautiful with lovely eyes. Your fathers would have contributed, but who is the builder of this? Your fathers are only investors, right? So please respect women. Women should be respected more and they should be worshipped, right? I went to Guwahati. Interesting story. They took me for a ride in the cruise. I asked them, what is the river? They said, Brahmaputra. Then immediately the man who explained said, this is the only river which is not worshipped. I asked him why. Male river. It is not Putri. Brahmaputra. Right? Then he added one thing more. Because it is not worshipped, this will become very wild often. Brahmaputra is very dangerous. People there in Guwahati told me it is very dangerous. It becomes very wild. It is not Ganga Ma. It is Brahmaputra. Right? Okay. For 148, I have to say so many stories. Section 148, previously for dispersal of unlawful assemblies, only male members were used. Now dispersal of unlawful assemblies, any person word was used. I told this in one academy. One judge in a letter and said, yes, women are capable of not dispersing assemblies, families also. But I don't accept that. Okay. So dispersal of assembly, now any person means Nalsa versus Union of India, all the 3 genders are equal. So any person would include male, female and 3rd gender also. Okay. Section 139. What are the 149. Use of armed forces to disperse assembly. That is, 2 words were added. District magistrate shall be dispersed by a district magistrate or any other executive magistrate. Okay. That is the one addition. Section 152. Conditional order for removal of nuisance. That is 152 subsection C. 152 subsection C is an addition that the construction of any building or the disposal of any substance is likely to cause conflagration or explosion should be prevented or stopped. Now, if at all there is a public nuisance by way of any construction, previously we will go only to a civil court for an injunction. Now 152 says, subsection C says, subsection C says, a magistrate is empowered to remove the construction if it is a nuisance, or he can stop that also. You should read that with 152 subsection 1 I Roman 3. 152 subsection 1 I Roman 3, to prevent or stop the construction of such building or to alter the disposal of such substance. Okay. Then 154, this has to be read with section 530. What is 530 once again? Yes, it is not that courts alone will do audio video hearing, even magistrates also, executive magistrates also can do that. Okay. 154 subsection, not a subsection, it is 154B. Hearing may be permitted through audio video conferencing, may be permitted. Okay. Okay. One request to the judges, or if law provides for audio video hearing, from 1st July you please encourage, if advocates comes to court, you please encourage them, please be in the home and addresses. Why? Firstly, there will not be problem in the court. Secondly, there may be some problem in the house if he keeps on sitting, right? That woman will keep driving him out, because the only relief of a woman in the house is this man's absence. Or the vice versa. This is all genderless words, man and woman, right? Third is, pollution will be less in the street. Pollution will be less in the court also. Okay. See, honorable judges, I am telling you very seriously, when science and law gives us some provisions, we should not feel egoistic that when a man appears in video conferencing, judges, many judges, they should not think, I am sitting in the court, I am coming all the way in metro and bus with all difficulties, you will sit in this thing. Especially when injunctions are argued, no. We will appear in audio video as an advocate, I will also appear in audio video. For what cases I will appear? Normal cases. Suppose I have to have an injunction or an extraordinary relief, what I am also thinking, I should go personally and show my face to judge. Madam, you are a good person.
No, in commercial courts we had that, applications travel from all over the state actually, Delhi, Hyderabad, Chennai, everywhere. Whenever we used to insist, no, they used to tell us, no, like personally if you come it is better always.
Madam, you are right. She is absolutely right. Because some courts, they are asking advocates, will you not come? You sit there. See, advocate is a person who is worried of his existence, survival, and he is also worried of the relief that he has promised someone to be done. So he cannot afford to sit there. My common prayer is, when law says something, if uniformly all the judges says, sir, law provides you this thing, leverage, please undertake that, then it will happen. All this, madam, we are in a transition stage. All this will take place. It will take some time. Our next generation, even if you call, will not come. You leave this old man like me, 40, 50. Just a law college boy comes out of the college. He will read this provision and he will read it to you. See, generation has changed. No, people, now children are not listening to whatever the elders says. So all will come. Then it is section 157. Proceedings, I told you all the stakeholders are bound by time frame. 157 says, it is proceeding to be completed within 90 days, which may be extendable up to 120 days. So it is time frame now. Then 162 has to be read with section 15. In the morning I said 162 should be read with 15. Executive magistrates, right? A district magistrate 162 or subdivisional magistrate or any other executive magistrate or deputy commissioner of police empowered by the state government of the district magistrate in this behalf may order a person not to repeat or continue a public nuisance. Okay? It is for prohibiting or not repeating a public nuisance. This is in section 162. Right. Now, next chapter 12, 168 to 171. Chapter 12, section 168 to section 171. What does it says? It says preventive action of the police. Earlier in CrPC also, from 149 to 152, all this was there. Right. One addition to this is section 172. What is 172? Persons bound to conform to lawful direction of police. This was not in earlier CrPC. Earlier CrPC gives the power to the police to prevent actions which are which may lead to cognizable offences, right? Preventive action of the police. Now it says, in executing these provisions, 168 to 171, police may pass an order, and any person who doesn't conform to that order, FIR may be registered as against that person for not listening to that orders. It becomes a cognizable offence. Okay, this is one addition. 172. Now we are coming to real BNSS. Section is 173, equivalent to 154. Okay. Now it is the real fun starts from here. What is 173? 173 is 154.1. We will just understand what is 154 for 1 minute. Okay. What is 154 of CrPC? 154 subsection 1 is important. Subsection 2 is also important. 3 is also important. This 154 subsection 1 says, every information relating to a cognizable offence, if given orally, shall be reduced into writing and by the station house officer, and to be read over to the informant, and to be registered in a book called as FIR book. This is 154.1. This is reflected in 173 subsection 1, not verbatim, with some changes. Right. 154 subsection 1 was interpreted by the Honorable Supreme Court in Lalita Kumari versus Government of UP 2013. Lalita Kumari versus Government of UP 2013. Same judgment, Lalita Kumari versus Government of UP 2014, another one judgment was there. Right. Question before the Honorable Supreme Court in Lalita Kumari was, what are the options before a police officer if an information regarding cognizable offence is given to him? Before Lalita Kumari, certain police people, they used to make an inquiry called as preliminary inquiry. Constitutional bench of Supreme Court said 154 subsection 1 starts with the word every. Suppose our Honorable Director tells you after the session is over, everybody should come to my chamber. Who cannot come? Who need not come? Except Chandru. Shama, beautiful answer, sir. Give him a clap, Ji. No, this clap is not a Kannadiga's clap. Yes. Ji, how do you think like this?
Because academic director is only asking us. So he is asking.
Okay, forget Chandru. Okay. Everybody should come. Who can abstain? Nobody. Director is coming and telling, anybody can come. How many of you can be there? Either all or no one. See, just 2 words. Only Chandru. Chandru has to be until tomorrow. See, this one word, every information led to a judgment of a constitutional bench, 5 judges stating that you don't have any business or authority to not register an FIR when FIR is given. You cannot disseminate or dissect and see that this is a false information, this is a true information, this is worthy, this is non-worthy, nothing can be done. This was said by the Honorable Supreme Court 5 judges bench in 2013. In this judgment, 5 exceptions were given. 2M and 3C. What is this 2M? Medical, negligence, matrimonial cases, then Commercial Disputes, then Prevention of Corruption Act, then cognizable offences with a delay of 3 months. These 5 exceptions were given, and Supreme Court said for all these 5 cases you can make a preliminary inquiry within a period of 7 days to understand whether it discloses a cognizable offence or not. This was laid down in Lalita Kumari in 2013. Then the government went and filed a CRMP, miscellaneous petition, and said 7 days time is a very too little time, so you expand it. Then in 2014 it was expanded as 15 days. So this is Lalita Kumari, right? What it is? 154 subsection 1 is mandatory. Point 1. Violation of 154 subsection 1 will lead to contempt of court. Point 2. Where contempt of court has to be filed? At any high courts where the party resides. 3 years it becomes an offence under section 166 IPC. Please listen very carefully. Now we are coming to a place where in present BNSS so many time frames were given. So many new orders were given. Whether they are all mandatory, whether they are all discretionary, whether they should be taken as may, whether that may has to be taken as shall, or shall can be considered as may. Now I have to deliberate on this portion first. People in Tamil Nadu fight for their rights so much. You all know that. Yes. Any new law comes, we will be the first to go to the Supreme Court and come back with no guarantee of result. Right? When I was a very small boy, 2002, I enrolled in 1997. If there is a strike, I am also an ordinary person. If there is a strike, it gives some happiness, because we are all basically from school have seen good strikes. So if that continues in bar also, you will feel happy. Right? 1999 saw greater changes in CPC. 2002 also changes, amendments. Salem Advocates Bar Association case versus Union of India. We all went to the Supreme Court with a fond belief that judges will say that amendments are invalid. Supreme Court full bench said all amendments are perfectly valid. Now also somebody will go. Result may be like this only. Right? In that what has happened, section 148 of CPC read with order 8 rule 1. What does it say? Return statement shall be filed, a return statement shall be filed, underline the word shall be filed within a period of 30 days. Court may extend it for a period of 90 days. 90 days. So total it is 120 days. Right? 30 and 90. Now question before the Supreme Court is, we are taught in law colleges, word shall means shall only. It is mandatory. Word may means directory. But Supreme Court says word may be shall in some cases. Right? CBI versus Master Bolu, 2021. Write this judgment, CBI versus Master Bolu. BHOLU, Supreme Court, full bench. CBI versus Master Bolu, Supreme Court, full bench. It says, Supreme Court says, word may is not always may. Word may will also become shall. What has happened in this Master Bolu's case, interpreting section 15 subsection 1 of the Juvenile Justice Act. What is 15 subsection 1 of JJ Act? Preliminary assessment. Whenever a small child commits a heinous offence, he will be subjected to an assessment called as preliminary assessment, to see whether the child is aware of the act which is committing, whether he is physically capable, mentally capable, and whether he is aware of the consequences. Firstly, a child which is of the age of 16 to 18, which commits a heinous offence, will be put into an assessment called as a preliminary assessment under section 15(1) of Juvenile Justice Act. In that they use one word, that a psychologist may be in the assessment group. The may be a psychologist. Now it went up to Supreme Court. This is a case where a second standard boy died in a toilet of the school. His throat was slit. The child bleeded and died. Immediately who will be the scapegoat in this country? For murder, principal will not be there. Sweeper, excellent sir, you are the true person sir. Sweepers, drivers, see those sweeper drivers are very godly sometimes, many times. They have all taken care of us nicely, right? Immediately that sweeper and driver, sir has rightly said, they were all arrested, thrashed severely, and finally a 11th standard boy was suspected, and that boy unfortunately was very tall, black and stout, disproportionate to his age. Assessment board says, no, he is looking very huge. So, he will be tried as an adult. See, from the morning, I am putting it in a funny way, but just look into the sensitivity of us. This goes up to the Supreme Court. Supreme Court said, what is this assessment? And the word may have a psychologist should be seen in the social context of the implication that will have on the society. Suppose a psychologist is not there, because what we will think, may have a psychologist, it is only discretionary. One boy's life is going to have a U-turn. This small child will be put to a session judge. Session judge also may get carried, because already the team has said, he is stout, he is looking like an adult, he is understanding everything. So Supreme Court said, this word may in 15 subsection 1 should be read as shall. This is one thing. Our Bar Association case, same Supreme Court, 2005 said, this word shall should be read as may, because in CPC, they have said that return statement shall be filed within 30 days, extendable up to 90 days, but no consequence is provided. Even though the word shall is used in any law, if consequence is not said, then shall will become may. One another judgment in Mukherjee versus Mukherjee, Division Bench, Calcutta High Court. Okay, you should write it as Mukherjee, M-O-O-K-E-R. Mukherjee versus Mukherjee. Calcutta Division Bench High Court. It is with relation to section 14 subsection 1 of Hindu Marriage Act. What is 14 subsection 1 of the Hindu Marriage Act? Excellent madam. Yes. One man or a woman got married. Immediately after getting married, he has a wisdom also. I have done a wrong thing, I have to come out. 14:1 said gate is closed. It is closed. You should suffer at least for 1 year. Okay. No application shall be entertained by a court of law for a dissolution within 1 year from the date of marriage, except in circumstances where they prove exceptional depravity and hardship. This word is there. This went up to Calcutta High Court. Now Supreme Court has also said. Now what they are telling is, the word shall does not have any other punishment clause or consequence clause. Any consequences, no consequences. So in any law, whenever a word shall is used, if no consequence is used in the subsequent sections, then it becomes, shall becomes may. Now come to Lalita Kumari. Section 154 says, every information relating to a cognizable offence, if given orally, shall be reduced into writing, read over to the informant. That's all. 154.2 says you give a copy. 154.3 says something else, you write it to the SP of police. Where is the consequence? Supreme Court but said in Lalita Kumari that you fall on section 166 IPC. What IPC 166 says? Any man who is in disobedience of law should be punishable. If you apply this yardstick to present BNSS, all shall will become shall only. See, I am repeating, 154 subsection 1 of CrPC, where the word shall for registration of FIR is used, do not have any inbuilt consequences in that law itself. It doesn't say send the policeman for violation to jail. Supreme Court take refuge from 166 IPC, which says a man who is disobedient of any law should be punished. Supreme Court said 150, all CrPC laws are law. If you don't obey that, it is punishable. Now Supreme Court, see, now in CBI versus Master Bolu, they said social intention has to be seen, social repercussions has to be seen. Now if you permit policemen, you no, it is all only mandate, not mandatory, it is only discretionary, you don't file FIRs. What will happen? Great anarchy will happen, injustice will happen because of delay. What we will write in the judgment? We will write one word, beautiful word. The lodging of FIR is with the inordinate and unexplained delay, and hence the prosecution has also not proved the case beyond reasonable doubt. Accused is always presumed to be innocent, he looks like a saint, we will send him to house instead of mother-in-law's house, right? So the Honorable Supreme Court is, this is one thing. I will tell you the latest judgment, Messrs. SCG Construction Infrastructure Private Limited, M/S, Messrs. SCG Construction Infrastructure Private Limited versus Chamankar. Messrs. SCG Construction Infrastructure Private Limited versus Chamankar, 2019 Supreme Court. Now, Order 8, Rule 10. What is Order 8, Rule 10? Commercial Code. Commercial Codes. Order 8, Rule 10, Amendment Act in CPC with regard to Commercial Code Act, it said return statement should be filed within 120 days. Our people went to Supreme Court, thinking that Supreme Court will say, no, it is like our Salem Bar Association, you can file it at leisure. Supreme Court said, 120 days, the provision says no person shall file a return statement beyond a period of 120 days, and court also cannot receive it thereafter. Now the tail contains sting. Now Supreme Court said this shall is shall. Now you have all this in your mind. In BNSS there are so many shalls. Shall is shall. Madam is very strict. Shall is shall. You can take refuge under 166 IPC if you want to say that a stakeholder is failing in his duty. And for you also, so many time limits are fixed. For taking cognizance, for framing charge, to dispose the trial, to send the bundle to the committal court, for pronouncing judgments also 30 days and 45 days. If you also doesn't oblige with the time frame, High Court will say whether it is shall or may. Okay. Justice is justice for all. Right. Yes, we will come to 174. What are the fancy things, new things introduced? One is concept of zero FIR. Should I explain zero FIR, or you are all aware of that? See, a cognizable offence, if it is reported to the jurisdictional police station, they will assign number. If a cognizable offence is given to a non-jurisdictional police station, he will not give a number. He will assign 0 and send it to, yes. One famous important judgment is our Jaggi Vasudev's judgment. You know that? Do not know? Jaggi Vasudev. His number, his case. A case was given by his father-in-law in Karnataka, stating that Jaggi Vasudev's wife died in a mysterious this thing in Coimbatore. Now, why I am telling this as an example is, father-in-law is in Karnataka. He lodges an FIR in Karnataka, stating that his daughter died in a suspicious circumstances in Coimbatore. This was registered as a zero FIR in Karnataka, sent to Tamil Nadu. Understand this? Yes. Now, previously, the word irrespective of the jurisdiction doesn't find place in 154. Now, in 173, the word irrespective of area, underline that, that gives the power to register zero FIR. Okay, irrespective, 173, third line, second line, irrespective, that is 0. You can read one judgment in Neelu Srivatsav, Vatsava versus state represented, state by NCT Delhi, 2021 Delhi High Court. State Neelu Srivatsava versus state NCT Delhi, 2021 Delhi High Court judgment, which will give you a clear picture as to the history of zero FIR, how it came, which law commission recommended. If you want to know about anything, you can read that. Another is, if a zero FIR is sent to a non-jurisdictional magistrate, how it has to be handled, right? It is in state of AP versus Ponnatti Ramulu. A zero FIR, if it is sent to the other jurisdiction, what is the duties and intricacies in that? Okay, then 173 subsection 1 Roman 2, 173 subsection 1 Roman 2. Now, from 1st July 2023, an informant or a victim need not go to police station for lodging a paper FIR. An electronic FIR can be registered from 1st July 2024. Okay. Second important questions to magistrates. I do not know how magistrates are going to sleep from 1st July 2024. No, I am seriously telling. See, now the woman or a man is going to type something and throw it to the police station. Finished. Within 1 second, that man will forward it to you. Hereafter, nobody will come and tap your doors. Now, what that fellow will write in the GD, FIR received by 12 o'clock, 12:01, sent to magistrate by 12:02. Our magistrate may open it by 12:03 or next day afternoon 12:03. What is the time of receipt in the court now? Your opening time is not receipt time. See, please understand this. Please understand this. Your time is opening time. He will nicely write, I have sent. The moment he sends it, it is sent time. That's all. You cannot say, I opened it only by this time. The moment it is thrown into your system, it is received time. You will open it after 1 year also. So, I do not know how are you going to handle this situation. He need not bring it to you at all, electronic things, sir. Just one tack, that's all. Gee, every day morning if you check also, what will you write in that? Or what you will record? It is all, if it is an express FIR, you are expected to put the time of receipt. Opening time is not receiving time. This is what I want to impress upon you. He can send at any time, no. See, a magistrate is a magistrate 24 hours. If he has 25 stations, received, what madam is telling is right. You cannot write that I opened it at this time. I received, that's all. So, your electronic gadgets has to be 24/7 and your wives will have a hectic time with you. Previously itself they will be asking, what are you doing always in the phone? Now it is indefinite. Some rules should come for all this because they are also human beings, right?
At present we are receiving from ICG, we are consuming data from police ID to
Yes, see.
and it is on a particular time slot. After 1 hour it will consume, after 1 hour, every hour.
See, can you expect a magistrate to get up every 1 hour and see?
Now no need to write
We don't need to manually intervene.
physically see that
Yes, so that is the time they send, that's all.
time and end of the same thing there.
So one harassment is not there, that he comes at any odd time and taps at the door. Yes. Sir? That is there. But FIRs, no. He will say I have sent it. Okay, so that is one thing. Then electronic FIRs, see, I will tell you like this. I do not know whether you welcome this zero FIR or not. We will imagine zero FIRs are really a very good measure in one sense. We will imagine a situation where there is a communal riot in certain particular place, or the assailant is a very strong fellow. That assailant, after beating you also, he will know that he will only come to this police station. He may also prevent you to coming from that police station. In those courts, the victim may escape and go to some other police station and say this reason as a reason and register an FIR. So see, everything has got a good and bad things. Imagine a village which is a very furious place where two people are fighting seriously, and the party who is a victim may not be permitted for a very long time to enter into the village itself. In those courts previously there is no other option. Now it is a good thing, right? And electronic FIR registration, signatures, the victim or the informant has got a time for 3 days. He can go and sign 3 days. My humble thought is, when you accept the evidence by electronic way, no, he can also sign an electronic form and send. This is some other thing which may also be attended by subsequent rules also. Digital signature, right? Then if you want to understand, I told you about preliminary inquiry, no? Such a preliminary inquiry is now provided in 173 subsection 3. Previously what Lalita Kumari said, it categorized 5 categories, 2M and 3C for preliminary inquiry. Now 173 subsection 3 speaks of preliminary inquiry. If you want to understand what is preliminary inquiry, you read Sirajuddin versus State of Madras. What is preliminary inquiry? Sirajuddin versus State of Madras, 1970. State of Gujarat versus Shyamlal Mohanlal Choksi, 1965. Sirajuddin versus State of Madras, then Shyamlal Mohanlal Choksi. State of Gujarat versus Shyamlal Mohanlal Choksi. It is 1965 judgment. Right? Okay, whether FIRs will be still uploaded? Yes, FIRs should be uploaded within 24 hours as was laid down in Youth Bar Association of India versus Union of India. Youth Bar Association of India versus Union of India. 2016 Supreme Court. Youth Bar Association of India versus Union of India, 2016 Supreme Court. All the FIRs should be uploaded by the police in their websites within 24 hours. Exceptions are women related offences, offences relating to national security, and POCSO related FIRs will not be uploaded. Okay. Next question is, now we are going electronically, whether charge sheet should be uploaded in the police website as a public document. Answer is no. Saurav Das versus Union of India. Saurav Das, SAURAV versus Union of India, 2023 judgment. 2023 Supreme Court says charge sheets are not public documents. It should not be filed, it should not be uploaded in the websites, and copy applications by third parties also should not be entertained. Right? In this context, also read another one judgment, Miss A versus State of UP. Miss A, capital A, within inverted commas. Miss A versus State of UP, 2019 Supreme Court. This says, please listen, Miss A versus State of UP 2019 says, even after the charge sheet is filed in the court, accused is not entitled for copy. I am repeating, we always believe once police files a charge sheet and taken on file, you can get a copy by applying copy application. Miss A was a state of UP, Honorable Supreme Court says that accused will get copies only in the stage of 207. Okay, you understand? Accused gets the copy of the police report not after the police files in the court, only after service of summons on him and only on the stage of 207. 207 is now 230. One improvement in 230 BNSS is free copies should be given not only to the accused but also to the informant or victim. You should give, court should give. Free copies should be given not to the accused alone. On the day if she is present, it should be given, or if she is with the advocate under 18 subsection 8, advocate should be given. Which advocate? Victim's advocate. Why? Victimology. BNSS speaks of Bharatiya Nagarik Suraksha Sanhita, that is People Protection Code. Just imagine Chandru was beaten by somebody. Chandru goes to the police station in the year 2010, lodges an FIR. After lodging FIR, Chandru do not know what has happened up to Supreme Court. BNSS says in every stage inform the victim. Right? Victim should be given, and in registration of FIR also, 173 also, 173 subsection 2 says copies of the FIR should be given to the informant / victim. That is, if Chandru is assaulted, my neighbor would have been the informant. Only my neighbor knows what is the case that he has given. Honorable judges, you understand the plight of the victim. One fellow will go something to his knowledge, he will file an FIR. But real victim will not have the copy of what is being given. And you just see this 230 and all is a welcome move. You give a bulk of paper to the accused and says these are all the things which are relying. Victim should know what is the investigation. One man is investigating something. See, we all have kept shamelessly from 1861 till 2023 just to see the plight of a victim. Where is the procedure for victim to participate? Where is the procedure for victim to oppose the bail? Free copies, you give volumes to this man. Morning itself I said, this is a man who has intruded into the privacy of somebody. He wants to protect his right to life and personal liberty. That was a person who has already lost his life right to personal liberty. Right? Now free copies should be given to the victim during the stage of 230, that is free copies. 232 says committal proceedings should be finished by the magistrate within 90 days, extendable to 180 days. And any application filed by any person, either the victim or the accused, in a case exclusively tried by the sessions, committal magistrate should not have any business in all these applications. I am repeating, if a proceeding is a committal proceedings, magistrate shall forthwith give the free copies. The word used is because committal proceedings are pending for so long a year. Now whatever it is, committal proceedings, magistrate shall forthwith give the papers and commit it within a period of 90 days, extendable to 120 or 180 days, and any application filed by either of the side to make any dilatory tactics, magistrate is not worried about on that, should put it to the main bundle and send it to the sessions court. This is 232, 230, and Miss A was a state of UP also. I have told you should not give copies on the request of the accused prior to 207 stage. Okay. Then coming back to section 173 subsection 3. 173 subsection 3 says police persons can make a preliminary inquiry for offences which are punishable more than 3 and less than 7 with the permission of the Deputy Superintendent of Police. One thing you should note that this is a deviation from Lalita Kumari. Lalita Kumari categorized 5 categories. Now BNSS says 173 subsection 3 says it is for offences which is punishable more than 3 and less than 7 years, right? 173 subsection 3 subsection 1 says so. In the morning I told you, investigation is not the domain of the police alone. 173 subsection 3 Roman 2, what does it say? Proceed with investigation when there exists a prima facie case. Suppose if the police person is pretending, I have to do a preliminary inquiry that it doesn't reveal a prima facie case. If a person approaches you under 175, now it is 175, previously it is 156.3. 175.3, you can, after reading the information, if you feel that the offence makes a prima facie case, the complaint makes a prima facie case, you can ask him to investigate in spite of the bar under 173 subsection 3. Okay. Then subsection 4. What is subsection 4? This is equivalent to 154 subsection 3. What was 154 subsection 3? If a police person, station house officer, refuses to register an FIR, then the content should be sent in a registered post with AD. Through that AD card, even in spite of the fact that if the SP of police is reluctant, then you can approach the magistrate under 156 subsection 3 of CrPC. This was the older law, right? Now 173 subsection 4 says, any person aggrieved by a refusal on the part of the officer in charge of a police station to record the information referred to in subsection 1 may send the substance of such information in writing and by post to the superintendent of police, who, if satisfied that such information discloses commission of a cognizable offence, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him. Previously, he will ask the SHO to do. Now, two things. Either he can do or he can depute any other officer, because see, she is the station house officer. She is reluctant in registering my case. I go to SP. SP says you go once again to her. What will be the mood of her? She will be very angry with me. What she will say? Oh, you went there. Finally came back. Now this is also a welcome move. Now the SP can say, no, you go to this fellow. And in this provision itself, they have said that you can go to the magistrate. See what it says? And such officer shall have all power of an officer in charge of the police station in relation to that offence, failing which the aggrieved person may make an application to the magistrate. Here itself they are telling that if you are aggrieved by all this, you can go to the magistrate. One judgment is Sakri Vasu versus State of UP. Sakri Vasu, SAKIRI-VASU, Sakri Vasu versus State of UP, 2007 Supreme Court. Sakri Vasu speaks of fair investigation, proper investigation, then speedy investigation, further investigation. Okay. I will ask you one question. Previously there was one section called as 173 subsection 2. Now this is 193. What is 173 subsection 2? 173 subsection 2. Charge sheet, police report, final report, challan. You can call it as anything. Charge sheet, police report, final report, then challan. This was 173 subsection 2. What is 173 subsection 8? Additional or further? Okay. Should the police get the power from the court or prayer? Should the police make a prayer or permission from the court for further investigation? You read 173.8, it will not say like that. 173 subsection 8 will give the power of the police for further investigation. That's all. He can do that up to judgment. He need not take permission from you. This was laid down in 173 subsection 8. One important judgment you all should read is Vinubai Haribai Malavya versus State of Gujarat. Vinubai Haribai Malavya versus State of Gujarat, 2019 Supreme Court. Vinubhai Haribhai Malavya versus State of Gujarat, 2019 Supreme Court. Okay. What was said in that Vinubhai Haribhai Malavya versus State of Gujarat? Two things, important things. Vinubhai Haribhai Malavya overruled a judgment of this. Vinubhai Haribhai Malavya is a full bench, 3 judges. It overruled a full bench judgment. Okay, which is a very strange thing, will not happen like that. Why it has overruled is, morning we read section 2H. We all morning discuss section 2H of CrPC. What is 2H? Investigation. 2H investigation, CrPC 2H was investigation, right? Now it is 21L. Before this Vinubhai Haribhai Malavya, it was believed that further investigation cannot be ordered by the courts after charge sheet is filed, right? Before Vinubhai Haribhai Malavya, it was believed that further investigation under 173(8) cannot be made by courts after filing of charge sheet, because a famous judgment was Devarapalli Lakshmi Narayana versus Narayana Reddy. Devarapalli Lakshmi Narayana versus Narayana Reddy. 1976 Supreme Court full bench. Devarapalli Lakshmi Narayana versus Narayana Reddy. 1976. This judgment held that police can file a charge sheet and can make further investigation when and whenever it pleases them. However, this judgment has also said court has no power for ordering for further investigation after charge sheet is filed. This judgment was held to be a good judgment from 76, 86, 96, 2006, 2016 for 43 years. 43rd year, Honorable Justice Nariman, Rohindra Nariman said, this judgment is per incurium because it is not valid in eyes of law, because those 3 judges have not understood what section 2H is. 2H is, investigation is not by police alone, it can be by any person, by magistrate. So magistrate also has a power. When police can have a power under 173(2), magistrate can also. See how beautifully it was read. Just seeing one provision, 3 judges said that is a per incurium judgment. They do not understand what is investigation. They were understanding investigation as the domain of police. So Vinubhai Haribhai Malavya said further investigation can be done by the court after charge sheet is filed until the commencement of trial. Please jot it down. Further investigation can be ordered by the courts or magistrates after charge sheet is filed until the stage of trial. This was laid down in Vinubhai Haribhai Malavya, right? Now next question. When do a trial commence? Because Vinubhai says you can order for further investigation only up to the until commencement of trial. It is court's power. Police can still ask for further investigation at any time. This is one thing. Now my question is, Vinubhai says court can order for further investigation until the commencement of trial. My question is, when does the trial commence? Excellent. Yes. Yes. Hardeep Singh was a state of Punjab. 5 judges constitutional bench says, Hardeep Singh was a state of Punjab, 5 judges constitutional bench 2014. Hardeep Singh versus state of Punjab. 5 judges constitutional bench says, commencement of trial is after framing of charges. Okay. A trial gets commenced after framing of charges. So, framing of charges, after the framing of charges, court cannot order for further investigation. This is one thing. Next question in Vinubai Haribai Malavya is, should the police obtain permission from the court for further investigation? Old court was silent in that. However, Vinubai Haribai Malavya says, police should obtain permission from the court for further investigation, especially when a trial has got commenced. Because trial judge moves in certain direction. He has got some report. This person, our person, no, he will do further investigation. He will go in the, yes, court will be going from Bangalore to Chikmagalur. Right? Then our policeman will go from Bangalore to Chennai. Now the court said, Vinubai Haribai Malavya, the Honorable Court said, police, even though there is no mandate in CrPC under 138.8 for the police to get the permission of the court, using the doctrine of contemporaneous expositio, that is contemporary position. Supreme Court said, invoking the doctrine of contemporaneous expositio, police should get permission for further investigation. That means, Supreme Court said, in this country, under 173.8, policemen are in the habit of taking permission. And Supreme Court has recognized this as a good habit. So, we are telling that the police in this country, for any case which is pending trial and trial is going on one direction, if you want to have a further investigation, you come and tell us. We will say whether it is wanting or not. See, I am telling, even the Parliament or the Supreme Court has got greatest faith in the system, judicial system, over and above the police. Right? This is what was the law laid down there. Now, because I have started with one thing, what is commencement of trial, I will also tell you what is termination of trial. Right? Anybody can help me in reading 353 of CrPC, not BNSS. You have 353 CrPC with you? 353 CrPC. Please read. You have abandoned the old CrPC now itself. Gee, it was with us from 1860, gee. Section 353 CrPC. Please read. Read, brother. Anybody can read? Ji. I want you to read that. (353) CrPC. Read. Anybody read? We are wasting time. Yes, ji.
The judgment in every trial in
Section 353 CrPC.
The judgment in every trial.
Please listen and also stop. The judgment in every trial
in any criminal court of original jurisdiction shall be pronounced in open court.
Shall be pronounced in open court.
By the presiding officer immediately after the termination of trial.
1 second. Judgment shall be pronounced immediately after the termination of trial. Now all learned judges tell me, what is termination of trial? Or when does a trial get terminated? Huh? When the prosecution rests its case, then? After? Arguments. Okay, any other better answer?
Evidence is finished.
Brother, please read once again, brother. I will give you a chocolate.
The judgment in every trial in any criminal court of original jurisdiction shall be pronounced in open court by the presiding officer immediately after the termination of the trial.
Judgment shall be pronounced by the presiding officer immediately after the termination of trial. My brother says, after termination of trial, you pronounce the judgment. But madam says a different answer, which I want to say in the mic. Please, madam.
Till pronouncement of judgment.
Excellent, madam. Madam says trial gets concluded after the pronouncement of the judgment. Right? Excellent, madam. Madam, I will give you a dairy milk, madam, today evening. You purchase and give, I will give it to you. See, reading the first principles of law, it gives us an idea that judgment is different from termination of trial, or judgment is something different. It happens after termination of trial. Why I am insisting this now is, Arjun Pandit Rao Kotkar is a very important case which will have more significance from 1st July 2023. Why? Yes. We all have become electronic. Right? Arjun Pandit Rao Kotkar says, you can receive court can receive 65B certificate until trial is not over. The word used is, court can receive 65B certificates until the time trial is not over. The word used is verbatim, trial is not over. I am not substituting any other word. Arjun Pandit Rao Kotkar says, court can receive 65B certificates until the trial is not yet over, which simply means that till the termination of the trial in one angle, right? Now, Abdul Yaqub Memon versus State of Maharashtra. Abdul Yaqub Memon, M-E-M-O-N, Memon versus State of Maharashtra. Beneath that, right, Sukhpal Singh Keira versus State of Punjab. Sukhpal Singh Keira, yes, U-K-H-P-A-L, Sukhpal Singh Keira, K-H-A-I-R-A, Keira versus State of Punjab, 2020 Constitutional Bench. 5 judges of the Supreme Court. 5 judges says, I will tell you, see, please listen, you can have the, you can be relaxed, put the pen and all. First, they have said when trial comes to a conclusion. Point 1, 5 judges bench says, a civil trial concludes when? Sir is telling closure of evidence. Any other better answer? Madam has said one beautiful answer. I have reserved a chocolate for her. What did she say? Sukhpal Singh Keira says, 5 judges Supreme Court says, a civil court's trial gets concluded on the pronouncement of dash. Okay, I will ask you another one thing. Civil judgment contains 2 parts. How many of you practiced in civil side as a lawyer? Okay. How many of you have been to copy application sections for getting a civil judgment? Whether the judgment and decree will be ready on the same date? One man sitting as a decree clerk, what he will say? You should give the mic to sir. Sir is telling the right. Sir, tell the answer frankly, sir.
Decree is not ready. Decree is not yet ready.
You say, sir, as you said. Decree?
Decree not yet ready.
Tamil, Malay, English, Karnataka,
decree no ready illa, sir.
Decree no ready illa. Okay. Now, you are thinking that judgment and decree is given by you. Right? Anji.
Judgment copy bandila.
See, I also is a victim of that. You apply copy applications, sir, judgment ready, sir, decree clerk type padikala. Decree clerk, decree type padikala. Adu oru ara pakkam da. 4 line. Mele decree, take the last portion of the judgment and put it. This gentleman will not do for months together. Right? You cannot file EP. But the other man, no, judgment debtor, he will get that, he will go to the appellate court. Right? Now, Supreme Court says, a civil trial gets concluded on the date of pronouncement of judgment, not decree. Supreme Court further says, decree is not coming out of mind of the judge because he has already drawn a judgment. It has to be taken on the administrative side and put it in a paper. So, a trial starts, it concludes till judicial mind of the judge is applied in that particular case. I am repeating, trial will only end when the judicial mind of the judge stops in that particular case. So, in a civil case, a trial gets concluded on the date of judgment. Coming to criminal case, trial gets terminated on the date of acquittal of accused. Now I am dealing with acquittal judgments. Criminal case, trial gets concluded on the date of acquittal. Coming to conviction. In a criminal case, trial gets terminated not on the pronouncement of conviction, sentence. See how beautifully they have said, because sentencing requires? Yes. This is Sukhpal Singh. So 353 was interpreted differently. Now come to Arjun Pandit Rao Kotkar. 3 judges says 65B certificate need not be filed on the date of filing of the copies. Even if it is missed at the time of trial also, court can very well receive it provided he says sufficient reason why he has not filed until the commencement of, until the trial is over. So please read that. And in Arjun Pandit Rao Kotkar, please take a copy. There are 2 parts. Okay, one is the judgment of Honorable Justice Rohinton Nariman. Another is the judgment of Honorable Justice V. Ramasubramaniam. You take both the judgments, read that, you will understand all the nitty-gritties of full electronic evidence. And don't get deceived by the other judgments, because all the judgments of Anwar, and all, everything was discussed in Arjun Pandit Rao. And it has also said under what circumstances 65B cannot be obtained or need not be obtained. Suppose the other side is not, the other side is having that. What the man will do, plaintiff will do, he will just say he is having that. Then he will issue process. Court can also use 165, court can use section 91 under CrPC also, 311 also. So the Arjun Pandit Rao Kotkar has elucidated beautifully what are the process of securing electronic evidence from the other side, and a man who is important of producing something cannot be compelled, need not be compelled. Right? This is also there. Then in Arjun Pandit Rao Kotkar, because today morning we saw section 2 subsection 1A. What is that? Audio video and this thing. In that it said state should make rules. Now Supreme Court Arjun Pandit Rao says, if you want to know more on electronic evidence, it has said on one thing, that is November 2018, a Chief Justice's conference was made and a meeting was made and a draft electronic, how to deal with electronic records. A draft paper was presented. That paper was presented by my Lord's Honorable Justice Rajesh Bindal. He was the committee of that electronic, chairman of the electronic committee. So take down that paper also. It has given all the procedures as to how to store electronic evidence, how to transmit, how to retain, how to use. Okay. Next question is, how you will give a copy of electronic record to another man. See, now that everything is becoming electronic. One case, you will all be knowing that it is Gopala Krishnan alias Dilip versus State of Kerala. Okay, I think public prosecutors will be aware of that. Prosecution case is that a woman went with a story that this particular man, Dilip, has photographed me, has assaulted me, and all these sexual contents are in the pen drive. And she gives a complaint, stating that he has taken up in all this and thing. Case came to the stage of filing of 207, furnishing free copies. Right? This man, accused, is telling, give me all the contents. She has filed a pen drive. Now the pen drive contains obscene materials touching the privacy of a woman. You understand? But that lady is telling, these are all things that he has made on me. But this man should know what it is. It is filed in the court by the prosecution as a pen drive. This man files a application under 207 stating that give the pen drive to me. Court takes a stand that pen drive is not a document, it is a material object. It will be marked only as MO. Accused says it is a document. Both of them go up to the Supreme Court. Supreme Court said what both are telling is right. Frame is the pen drive, content is the document. I told you in the morning, judges are plain and wise people. See, for this you need not read any law. Prosecution is telling that frame as a pen drive, yes. This man is telling that without knowing the content inside the frame, I cannot conduct the case. This is also yes. Then Supreme Court said, what prosecution telling, what both of you are telling is right. And why I am insisting on Gopalakrishnan is, they have stated, they have held so many strategies as to how a copy of electronic document has to be given to the other side. See, now I am telling, a woman is complaining on Chandru, that Chandru has made all of me obscene, Chandru has made me naked and doing this, blah, 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 blah and all. Now Chandru is taking a stand that she has given only cut copies, right? She has initiated all that and she is a party to that. Document which she files before the court of law will be a altered copy. Now, what is the nature of copy that prosecution or the court should give to the accused? Supreme Court in Dileepan says, you cannot give a copy, you should give a cloned copy. CLONED. What is the difference between copy and cloned copy? I told you, you should explain to me like you should explain to a villager. Gee, tell me, see, you should explain like you should explain to a villager. What is cloned copy means? The original document would have underwent alterations, additions, modifications, right? Tamperings, or it would be like an immaculate woman, nothing. Morphed. Whatever is inside, including the message of altering, additions, you give the cloned copy, it is just original, that's all. It is not taking a printout and giving. If you take out a printout from an electronic this thing, you are cheating the other person. So cloned copy is replica what is inside. It will reflect everything. If you add, if you subtract, if you do something, everything, so the accused will now impress upon the court, see, this is a document where there are a lot of additions, modifications, alterations, so she has not come to the court with a clean hand. She is projecting a favorable document on her side. So, Dileepan's case has already said, Gopalakrishnan as Dileepan has already told you the guidelines of furnishing an electronic copy to the other side. Suppose this woman is telling that my nude photo is there. Accused wants it. Can that be given? What is the privacy of the woman? Now Supreme Court in Dileepan itself says, Dileep's case, if a document which the court feels should not be given and it is in the court, the advocate, the party concerned and an expert should sit on that in the court and peruse it. By expert? Yes, we were talking about that only. No, expert will now see whether it is tampered or not. And accused, if he sees that, he will say, sir, I am not at all that man, that sir.
Sir, sometimes what happens is the police would have seized that material, sent it to FSR for examination. That will be sealed by the FSR. Now, if I open, then that if the court opens, then again it will become like without not in the stage of trial you open. So this 207 is given at early stage.
See, 207, court, see, either the court should give it at the 207 stage.
No, see, the court has no business in this because we are neutral party. The police have seized it, sent it to FSL. FSL, the original is with them.
Yes, it will be with them.
With them. Now a copy has to be
Yes.
Now, who has to give the copy?
All free copies as per the new CrPC, police should make copies.
Correct.
Yes.
So what is the role of court? Why should
Suppose if some documents which the police says or if the complainant says my modesty is involved, it should not be given. Obscene things,
Sir,
contents.
that is the allegation.
You should not give. In that case, the police will not give. Or
His right is different.
that is the reason I said in Gopalakrishnan, for that only they are telling that 3 people can come and see in the presence of the court. So you should open a docket and say, as per the directions of Dilipan alias Gopalakrishnan, the case is like that, I am permitting them to see. Or else how can he conduct the trial? He will see that would be amounting to violation of natural justice. So tell me, sir, whatever is the doubt, tell me.
No, because at that stage, court cannot intervene, see everything and then tell, okay, a copy has to be given. It is between the...
At which stage? See,
At the stage of
I have
forwarding.
understood what the Honorable Judge is telling. Please listen, 1 second. Free copies are given under section 230.
Pre-trial stage.
Yes, pre-trial stage. Yes. Then, what judge is telling is, I am not aware of the document. Now, policeman who is always instructed right from the FIR that if the FIR also contains any obscenity in that, you should not give the copy of FIR even to the informant, and or you should give the copy after redacting. Right? Even a charge sheet, if it contains like that, courts are mandated to redact and give. Now, presumably there is a document which is a matter of controversy. That document is in an electronic form in a pen drive, right, or in a CD. This document copy, contents of that has to be shown to the accused.
Given to, not shown.
Obscene should not be given. The mandate...
No, but he needs to get it analyzed from his lawyer or...
He can send it from court. He cannot have it.
This is a problem, sir.
No. See, victims... see, Honorable Judge, there are 2 things. Balancing the right of the accused and protecting the victim. When that... See, one woman goes and says, Chandru has stripped me. And this is the photo. Chandru cannot ask the photo once again back. Chandru can ask the court that the photos or the contents which the prosecution has given it to the court can be sent to an anthropologist or a forensic scientist thing, and anthropologist will say, is the photo resembles Chandru's photo, is the photo resembles...
They will not give. That is the problem. FSR will only say...
In Tamil Nadu, in High Court, thousands of cases we have seen where if suppose I am implicated in something, I will tell you, we will go a bit detail after some 5 minutes also. See, there are 2 things. Now, 1920, this is not required. See, there are 2 things. One is, there is one act called as Identification of Prisoner Act. 1920. What does that act says? That act says, police and the prosecution can have photographs, footprint, fingerprint of the accused. This was the act of 1920. Act called as Identification of Prisoner Act 1920. This act was once again in 2022 was amended as Criminal Law Amendment Identification of Prisoner Act. Once again it says you can take photos, footprint, fingerprint and blood samples. Then coming down to Evidence Act section 73, court can compare signatures, right. 311 is another provision enabling the court to call details from the accused, right. Now, one judgment of the Honorable Supreme Court in State of Bombay versus Katti Kallu Ogad, 1961, 11 judges of the Supreme Court, State of Bombay versus Katti Kallu Ogad, right. The question is whether incriminating substances can be taken by the accused, or can accused be compelled to reveal incriminating circumstances. Supreme Court said Article 20 subsection 3 of the Constitution speaks of what? Article 20 subsection 3 says, no person shall be compelled to be a witness as against himself. Right? Amma? No person, it is doctrine of self-incrimination. Yes, doctrine of self-incrimination. To what extent that doctrine of self-incrimination will help you? Supreme Court in 2019 in Sonveer alias Somveer versus NCT Delhi, please read that judgment. PPs you can read that. Sonveer alias Somveer, S-O-N-V-I-R alias Somveer, S-O-M-V-I-R versus NCT Delhi. 2019, Supreme Court said, in India, accused don't enjoy the right of Mirandaism. What is Mirandaism? Miranda. Cool drinks. Miranda versus State of Arizona is a famous judgment. Miranda versus State of Arizona is a famous judgment of United States where the accused has got a right of silence from the time of police examination. See, police will call a person that I am suspecting you as an accused. You need not answer anything to me. You can maintain right of silence. So they believe too much in their investigatory skills. Supreme Court said in Sonveer alias Somveer, such right of Miranda, such Miranda right is not available in India because section 160, 161, 162 read together of CrPC, what does it say? Police can summon any person acquainted with the fact of the case and that person shall truly speak of everything. So in India, accused do not have a right of maintaining silence with the police. However, 164, if the accused is taken to the magistrate, magistrate will tell him the right. What he will say? You do not have any duty to confess. And if you confess, yes. Now, policeman vis-a-vis Article 20 subsection 3 vis-a-vis doctrine of self-incrimination, Chandru is arrested for an offence of rape. Right? Chandru need not say, I will not give my sperm. You cannot take my blood. I will not cooperate. I will not speak out. Now, whatever test, no, but for incriminating testimonials, police can compel anything from me and take. In this Identification of Prisoner Act, it says by making necessary force. That is, if I don't react to, if I don't pose to the photo, they will give one slap and say this is necessary force, pose. And there is a famous saint who was sometimes in Tamil Nadu and sometimes in Karnataka. Right? He said, I don't have a sperm. And our investigating agency were still begging with that fellow. You know, court says, medical science says, see, our police, they should read things more. A man has raped a woman, and in that woman's dress, spermatozoa of this man is there. Now what police does, they arrest that fellow and beg him for some sperms. That fellow is non-cooperative. What is the best sperm in the human body? Blood. Any material that the sperm contains, that DNA material is in the blood also. You cannot say that I will not give a blood. Necessary force can be used for drawing blood samples. Right? Now, only one thing was absent in India. What is voice test? No law has given anything on that. But for that, there is law for everything. Handwriting, blood samples, all this. So, in Ritesh Sinha versus State of UP 2019, Ritesh Sinha. Ritesh, R-I-T-E-S-H. Ritesh. Ritesh Sinha versus State of UP 2019. Supreme Court said, Sinha. Supreme Court in 2019 said, there is no law in this country for voice test. UP 2019, Ritesh Sinha, Honorable Supreme Court said, there is no law in this country for voice test. We use Article 142 BAIC rules unless and until law is made. Now law is made in BNSS section 346. So one thing is, my photos can be taken and it can be sent to forensic experts. Suppose I am firing a man. Right, I had a case. I intended to conduct it in Palani, a place in Dindukal. One old man, because of the quarrel with the next house fellow, he was practicing firing in his own house. He is 76 years old. I will send that video also today. You all enjoy that video. The precise firing. Even our policeman cannot do. That fellow came, he placed one hand over his another hand, tuck, tuck, he shot, two fellows fell down. Neighbors, for no reason, just some small boundary dispute. Right? He fired two people. Now Tamil Nadu police, what they did, this man was firing, the video was not very clear. This man arrested him, took him there, photographed him, and took the CDR also, sent both to Tamil Nadu Forensic Science Laboratory with a query to Anthropology Department, whether this man in the photo corresponds to that man in the video. Answer is yes. And the old man engaged me some 6 months back. Now he is with his maker. He died. So Chandru is very fortunate. Okay, we will meet tomorrow then. Bye bye. Thank you so much.